Hello, good day. Hello, Greg. How are you? How's everybody doing? It's Thursday. We've made it to Thursday. That's good. Oh, from Dallas. Hello. Welcome. Welcome. Good to see you. Good evening. Yes, good evening. Hello. Hi, Sunny. I'm doing quite well. Thank you very much. So far, so good. Oh, Kansas. Oh, my goodness. Unindicted, that's a plus. Yes, that's now our standard, I think. If you're unindicted, you're doing well. What are the rings today? I have another mood ring actually today. It changes color a lot, so I thought that might be fun for tonight. California, Georgia. Whoa, hot Georgia. Oh my gosh. Ooh, Tennessee. Yeah, it's scorching out there. Oregon, well, welcome. Good to see you. Boston, very good. Excellent. Love that. Texas, oh my gosh, it's just scorching out there. It's screaming hot, as some people would say. Screaming. Wisconsin, okay, excellent. 106, yeah. It's really unacceptable. It's almost, how I would put it is, the heat is almost assaultive. It's almost criminal, in my opinion. South Carolina, wow. Yes, California, hello, welcome, welcome. Yes, oh, Hotlanta, yes. Oh, Maryland, okay. Kentucky, excellent. Florida. This is just a cover. It's a tablecloth, actually. It's a dark blue, so it kind of looks like denim. I had to put a cover on. I had a couple of incidents. So I had to kind of protect my cover here, but happy Friday Eve. Yes, I love that. Yes, Chris, I saw that. She said October, and the judge said, sounds good, let's do that. So yeah, it will be very interesting. Jim Jordan's asked for evidence. Yes, I'm sure. But, she's been in the hot seat before throughout all of these proceedings, so I'm not too worried about it. Ooh, Los Angeles, welcome. Yes, I saw that. I saw October 23rd. Well, and Cheesebro had said he wanted speedy, and so when that got in front of the judge, I think the judge was like, okay, let's do that then. Highlighter incident. No, no, my camera had moved and had just kept sliding backwards. And so this way I want to make sure everything's covered just in case I have an unwanted camera movement, so to speak. She is relentless. I think that's an excellent description. Excellent. Yes, it was Cheesebro. Yeah, he's the only one that's requested speedy at this point. So, and she said, well, fine, let's do it in October. And the judge said, okay, let's do that. But, I think it's, a lot of people think, a lot of times when our defendants want speed or ask for speedy, it's kind of a power play. And so if you call them on the power play, many times they'll kind of go even up to a couple of weeks before trial and then finally turn around and say, never mind, we waive. So it can be kind of a power play for sure. DC case just got dropped. Ooh, not that I've heard of. I highly doubt that. Oh, that can't be true whatsoever. Well, it's fascinating. It'll probably be the single biggest case of my lifetime, so I'm definitely very interested in it. Which of the RICO charges are against the guy who isn't getting out on bond? I'm not sure who isn't getting out on bond yet. I have not seen that. I went through, we've got about half, maybe 2/3 of the defendants have bond agreements, but I wasn't sure who hasn't had an agreement yet. They still have till tomorrow. You were a kid during the OJ trial. Yeah. I mean, this is pretty major in the world of law, definitely. Pretty major. Now, Barbara, that's not very nice, is it? No. Yes, I think it'll be an interesting educational moment, I think, for all of us. I think he's the one that's asked for it, that's asked for the speedy trial. And so this will be a situation where we find out whether or not he really meant it, because he could waive. He can waive at any time. So this could just be a tactic for him to go forward. But, well, Russell, it might be political, but we have, law sections that have been violated. So, I mean, whatever reason, we've got code sections that were violated. So, and found to be violated by probable cause. We certainly don't have guilt beyond a reasonable doubt, but we've got violations there. Yeah, I think it'll be very interesting in a few weeks to see what happens. Why do you act so smart when you're not? Well, that's a lovely question, Becca's sister and Maud. Do you think you're smart, Mildred? Do you ever act like you're smart? It's a good question. Nope, I'm serious. It's not a joke this time. Nope, I'm serious for sure. I am as serious as some serious things. Yes. Well, fair enough. TLJ, everyone's got their right to an opinion as long as they're not breaking the law with it. So that's really the key here. Hi, Cozy. Welcome in. I came on just a little bit early tonight just to kind of say hi and get everyone situated. So, yeah, they don't. I think it's hard. Oh, listening at work. Okay, excellent. Thank you. That's nice. Good for you, working hard. Yes, I didn't write these documents. I most certainly did not. Nope, I didn't. No. Nope. I think Mark Meadows broke the law. Well, according to the indictment, he did at a level of probable cause. So then yes. I mean, beyond a reasonable doubt, we don't have that yet. That's for the trial jury to decide. Going to be the trial of your lifetime. It's going to be bigger than the mafia. I agree, Jeffrey. I feel the same. That's really why, it's so interesting, because it really is, going to be the biggest trial, I think, in my lifetime too. Yes, I've heard that. I've heard that today's the day. We will see how that goes. But I really don't know what the details are. I really don't know how they go about that there in Fulton County. Yeah. Oh my gosh. Oh, welcome, mods. Welcome. I'm so glad to see you. This is a mood ring tonight. This particular one changes really quick, so I thought it would be a little extra fun as we go through, because the color changes almost constantly, so it'll be pretty fun. Yeah. He's on the way. Yeah, we will see. Yeah, I think it's going to be one of the top. Absolutely. It's got all of the trappings of an amazing case. We've got constitutional law questions. We've got the highest position in the state questions, or in the United States. We've got all kinds of stuff here. It's got all the elements of an amazing case. I think the thing about it, Austin, is that the jail is actually separate from the courthouse. That's how it is also in my jurisdiction. Our jail is in a different place than our court. So when you go in and get fingerprinted and booked in, you're at a different location than our actual courthouse. I think the jail kind of runs all the time. I mean, visiting hours are set and so on, but, they're kind of running all the time. His plane was delayed due to weather. Interesting. Oh, yeah, of course, Austin. Of course, absolutely. Great place to ask good questions. Paying a potential witness's legal cost obstruction. Well, I think it depends on the intent behind it. If you're just, paying travel expenses, a lot of times the state will pay for travel expenses for a witness to come and go, depending on the situation and what the law says. So it really just depends. He's landing. Oh, okay, that's good to know. Yeah, it's always open, it's a bad place. That's unfortunate. I hate to hear that. I hate to hear that about any jail for any defendants. I hate to hear that. We are humans, and, that minimal level of human dignity would be nice. The judge already denied this order. Correct. Yes. I'll be jumping in here to the details on all of these orders. I've got some interesting things tonight to be going through, but I will take you through all of those. Just kind of getting everyone in. Let me make sure I pull up what's. I want to make sure I've got my docket in order. All right, so I've pretty much taken us through almost all the dockets up until the 13th docket. So that's where I'll be starting for tonight. I'm wasting tax dollars. Oh, I'm not using any tax dollars. What? This is for free. I'm not charging anybody anything. Oh my goodness. That's crazy. That's just, I'm thinking about it. I'm like, whoa, are there any taxes? I hope not. Completely unknown. Wants to tell the judge how to handle his case. I agree, Freddie. I think he's really trying to push things around. Oh no billable hours. This is all pro bono, just for fun. This is after hours for me. No taxes. The plane just landed. Oh yes. I'm happy to do it. I am happy to do it. I do lots of seminars, and I do lots of different teaching engagements. But when I come and sit down with everybody here, I'm happy to just help out as best as I can. Oh, no cash apps. No, thank you. None of that. Oh, yeah, I'm just happy to help out as best as I can. I think there's just a lot of misunderstandings, so I want to kind of see if I can help a little bit. Which side are you on, plaintiff or defendant? I'm on the side of the Constitution. I'm just here to set out what the law is and what it means and how it works. That's it. I don't have a side. Good evening, James. Welcome. Yes, jurisdiction's been established, although we do have this idea of notice of moving it to federal court, which we'll talk about tonight. So, okay, very good. Yes, the mods, fantastic. All right, well, I think I'll go ahead and get started here, everybody, if we're all right with that. Yeah, I do keep it to myself. I find it not to be very helpful whenever I'm teaching or giving information to kind of color it with my own views. I don't find that to be, with my own political views, I don't find that to be particularly helpful. So I try to stay as much as I can outside of the political world. So federal court, I'm not sure if it'd be biased. I think the issue is I'm not sure it's really the appropriate place to have it because, we're dealing with state charges. But let me go ahead and dive right on in here. With the court. Yeah, I don't know. I mean, that's kind of their job. That's kind of what they're supposed to do in the DA's office. Yes, I've got a bit of a mood ring tonight, but this is a little different one. This one changes colors really fast, so it'll change colors quicker, I think, just for fun. So, yep, the law's the law, absolutely. All right, well, let me go ahead and dive on in. We're in document number 13, and this is specific to Mr. Meadows' case. And this is what I think is really important is he's had so many questions about whether this should be in federal court, and the court's gone back and forth over it. So I wanted to kind of take everybody through the documents that have been filed. So we'll start here with document 13, which is a notice regarding a prompt hearing. So he had requested a hearing and actually had suggested a date to the court, which can be helpful if the court requests that, but the court did not really request that. So that's the first thing, is this idea that he would like to have a hearing to go over it. He also then requested oral arguments. Now this is document 15, which came up next. Now I'll keep you up to date on all of the other documents. I didn't print every single numbered document out because some of them are just certifications. So for example, document 14 is a certificate of service, and so I didn't print that out. It's just a service. But this is the oral argument that he had requested. He set out a motion to dismiss, claiming basically he had immunity under the Supremacy Clause. Now, his entire argument here is that he was chief of staff, and that gave him a kind of immunity or protection because of the scope of his job was why he was involved in what he was charged with. Just to review, he was charged with the RICO count, which everyone was charged with, and then he was charged with count 28. And 28 is solicitation of violation of oath of a public officer. So he was involved with requesting people who had sworn an oath to violate that. That was his second count. And he's claiming he did that and all of the RICO situations because of his job as chief of staff. So that's what he's asking. He's moving. This is his motion. So just to keep things clear, I will just highlight in orange if it's defense motion and in green if it's the government's motion, just to keep it clear for everybody. So he's moving to dismiss, setting forth basically that he has immunity under the Supremacy Clause. And so he's walking through and saying, hey, I want to have a hearing so that I can argue this out. My attorneys can argue this out. That's what this one is about, his motion here. So then we bump to the next piece right after he filed that motion for an oral argument, and he filed a notice of a corrected brief in support of his motion to dismiss. Now on my last live, I went through, or the live before that, I went through his motion to dismiss and his notice for removal to federal court. He's asking to dismiss again, saying under the Supremacy Clause, because he was chief of staff, he's not to be held liable. But what's interesting about this that I thought was very interesting is that he had made mistakes in his previous filings. Okay, does that sound familiar to anyone? So he actually is providing a corrected brief. And if you look down here, it says the corrected brief fixes typographical errors contained in the brief that was already filed. He's asking the corrected brief be substituted for the prior filed brief. So this is an actual hard copy of, one of those clerical errors that we've been talking about so much when it comes to that sheet of paper that was filed before the indictment came out. This is exactly what I mean. We make mistakes all the time. And so that's what he's putting here in this motion, which is document 16. Now, after document 16, we have document 16-1, which is his memo, again, supporting his motion to dismiss. Yeah, they didn't proofread their first filing. Yeah, it happens. It's really, it's something that we should all, in the legal field, we should all be embarrassed about, but it just happens all the time. And, we don't proofread, or our paralegals will make a change to something our paralegals did, and rather than our paralegals who are on top of everything, we go forward and file it anyway, and then there's trouble. So anyway, here we go. This is his corrected memorandum. Now, I'm not going to be reading through the entire pieces of everything until we get to the order. I'm just kind of summarizing here for you because I don't think we need all the language to really understand where he's coming from. But this was filed on August 19th. All right, so document 16-1. This is his explanation for why he thinks this should be dismissed. And again, this goes hand in hand with his removal request to federal court. He's saying he's immune to the state's prosecution under the Supremacy Clause. The charged conduct carried out while Mr. Meadows served as chief of staff to the president has a nexus with furthering federal policy. Now, if you remember those 161 acts under the RICO Act and the acts that he was involved in, he's saying he did those things not in furtherance of a goal, which was set out for RICO, but because of he was trying to further federal policy, which is a bit of a stretch. Next, he says his conduct can be reasonably be characterized as complying with the full range of federal law. And again, that's another thing where he's trying to say, whatever I did was in compliance with the law. Now, a quick side note, and I won't give it away too much, but a quick side note here that I think is really important for everyone to remember is that we do have something called the Hatch Act. And under the Hatch Act, it states if you are a federal employee, you cannot, while you are working during working hours or wearing your uniform, something like that, or presenting yourself as the federal employee, campaign for a political candidate. You're not allowed to do that under the Hatch Act. That is a federal law, so let's keep that in mind. So he's saying here that his conduct can reasonably be characterized as complying with the full range of federal laws. So if he is doing anything to campaign for a candidate, that would be a violation of the Hatch Act, which would be a violation of federal law. So that would kick out B automatically. Just kind of keep that in mind. So he's saying he did everything he needed to do as chief of staff under letter A. Then under B, saying even if he didn't, he was in compliance, which again could be a conflict with the Hatch Act. Well, yes. Here's the deal. I've got a grand jury indictment. I don't know about the politics. Wait, they're already gone. Are my moderators, you guys? But here, we're talking about indictments here. We're just talking about the law. We're talking about laws. We're talking about documents and rules. That's all we're talking about. I'm not talking about politics here, other than the fact that anything he did that was a political campaign would disqualify following the law under the Hatch Act. So that's kind of how we did it. We didn't enforce the Hatch Act during his entire administration. True, but that was because of his administration. But the court, if he's claiming he didn't violate federal law, and the court views the Hatch Act as federal law, the court's not there to enforce the Hatch Act. The court is there to view, is this a federal law that was violated? Whether or not they allowed it to happen isn't the issue. The issue is he's claiming he didn't violate it, and the court can take a look and decide whether he did or not. So next we've got, even if the court were to conclude that Mr. Meadows is not entitled to the Supremacy Clause immunity, his acts would be protected by the First and 14th Amendment. So that's our freedom of speech. And under the 14th Amendment, equal protection, due process, those kinds of issues. And again, we've talked before about how freedom of speech has limitations. So freedom of speech is not necessarily an effective defense when you're being charged with false information or asking someone to violate the law because of your speech. He'll go in and explain his rationale. I've kind of gone through this before and gone through his explanation under the Enri Neagle case and citing Justice Kagan back into all of this. And he's just going on to say, Chief of Staff to the President and leader of the Executive Office of the President, he served a critically important advice and assist function that has been firmly entrenched in federal law for nearly 100 years, which is true. But yet, on the other hand, we still should have compliance with the Hatch Act actually under the law. Maybe not within the executive office at the time, but under the actual law, there should have been compliance. That takes us then to one of my personal favorite documents, document 17, which is this emergency motion for immediate removal or for an order prohibiting Fani Willis from arresting the defendant, Mark Meadows. This is a very interesting piece here that he has filed that I'm sure many of you have already heard of. And this was filed August 22nd. So he comes in and is saying he's moving for the court to promptly permit removal. And this is just, in the legal field, this is a lot. You don't go forward and push your court around just out the gate. I mean, you can ask, you've got legitimate questions, legitimate motions. Of course, you're going to want to ask for that. But when you come in with this level of, nerve to say to the court, like, I want you to make your decision up, I can't be brought in, that takes a lot. It takes a lot to do that. And they're telling the court what they can do. The court can effectuate relief by issuing an order to the DA, who's a party to the matter, before the court, prohibiting her from arresting or causing the arrest of Mr. Meadows before the Monday hearing. Who does that? I mean, I've never seen, I'm I would say this could definitely be a pro se situation in most situations, but for a defendant to say to the judge, tell the DA not to arrest me, I mean, that's asking a lot. You're really asking a lot. So there is there's a lot of questions there. And then this idea that we need immediate relief in order to kind of prevent this arrest from occurring, which was a lot. It really was a lot. Can judge throw it out? Yes, the judge can. The judge can say this is actually, insufficient, irrelevant, inappropriate, all of those things. And in this particular case, the court does come back later and kind of sets out like, what are you doing? But also asking for the DA to respond. So we don't have a final decision on this, but we have Fannie's response. So let's get through where he's asking for Fannie to not have to be able to do his job. Throw everything at the wall, see what sticks. It happens. Absolutely, it happens. Especially when you've got this many charges in this kind of a case. You're going to really want to try it out. So he's going again into the supremacy clause arguments, which he's really relying heavily. He's claiming that, this time phrase, that there's a sufficient to withstand a summary remand, and he's trying to use a lot of different legal jargon in here. This is where I think it gets interesting. This morning, District Attorney Willis rejected the proposal out of hand and made clear that she would arrest Mr. Meadows before this court's hearing if he does not agree to bond terms and voluntarily surrender. And this is I think what's really made the rounds quite a bit. I'm not granting, and this is a statement made by the DA, I'm not granting any extensions. I gave 2 weeks for people to surrender themselves to the court. Your client's no different than any other criminal defendant in this jurisdiction. The 2 weeks was a tremendous courtesy, which is very true. At 12:30 p.m. on Friday, I shall file warrants to the system. My team has availability to meet and discuss reasonable consent bonds Wednesday and Thursday. That's where that information came from. And again, he's just going on to complain about that some more. So I won't spend too much time again on this particular document, mostly because there's really no legal grounds for what he's doing here. The court can also issue an order enjoining the DA from arresting him before this court's Monday hearing. Again, he's just, begging the court, like, please make it so the DA can't arrest me, which is just... You just don't do that. Typically, it's really, it's not something that you normally see. Yeah. And there we go. That moves us to the next document. Again, I don't want to spend too much time on that. She's got a great response that I think is really worth the time to spend on it at this point. But declaration of... This, by the way, because it's document 17-1, it means this was an exhibit attached on to his motion. For Morin in support of emergency motion for immediate removal. So he's got another attorney in here. I'm a partner with this law firm, and one of the attorneys representing Mr. Meadows in this case and has been admitted pro hoc vice, submitting this declaration in support of his emergency motion for immediate removal, which I think is fascinating, again, where an attorney is coming in and saying, oh, I do represent him, and I'm going to write a special motion saying that he should not be arrested. Like, this is just not typical paperwork. We just don't see this. Setting out the different exhibits, 2, 3, 4, 5. Again, there's a letter here to the district attorney. I feel like there's some tattling going on. Like, if his attorney, somehow tattles maybe on the other side, that the judge will understand. But, we can get upset with our DAs all the time, and we can put their names in our motions all the time and call them out. But to say you're not allowed to arrest somebody, and when that's, their job description, very unusual. This is a motion to keep the DA from arresting him. And then I'm just showing you the exhibits that were attached to it. So this is his motion. He's saying this is an emergency motion that he wants the judge to tell the DA that she cannot arrest him. Now we've got Exhibit 3. Again, I'm not going to spend too much time. These are just letters back and forth between the DA and his counsel, where she's saying you need to come in like everybody else, and counsel is saying we don't want to. And then he is attaching all of these as exhibits to his emergency motion to not be arrested. And as we all know, that did not happen. He was brought in. He did turn himself in and go through the procedures. So this motion did not work. But wrapped up in this motion is this idea that he's got immunity, that he should be allowed to get out of all of this because his case should be dismissed because he was chief of staff. So the reason I'm taking you through this is we get to this response from the DA explaining why no, he is not, he should not be in federal court. I think entitlement's a really good word. I think the legal system is, we use a lot. There's a lot of strategy involved. There's a lot of different things we can file. But for someone to come in and try, especially when you've got 19 defendants listed, all of these defendants, and he's the one that's coming in and saying, I shouldn't be arrested. I should be allowed because I'm asking for a dismissal. I think it's pretty bold. Yeah, it's pretty bold. It's, again, I didn't think I would see that. Mr. Meadows right here. This is who it is. Okay, Georgia versus Meadows. And this is the one of the defendants out of Georgia. Yeah, oh yeah. Bold's one word for it. Arrogant. Yeah. I mean, have any of the paralegals or anyone working in the legal field, have you seen an order where an attorney asks a DA not to arrest them? I mean, I've not seen it like this before. I mean, there's been discussions, we've had phone calls, but I've not seen an order where they're asking the judge to issue. Yeah, I know, right? He's actually asking the judge to say. And how could the judge possibly intervene in that way and tell the DA that she doesn't have the authority to arrest someone? That would be a huge issue in the legal system. Yeah, absolutely. Exactly. The DA has the authority. You're right. Yep. All right. So next we've got notice of removal of the Fulton County Superior Court indictment number. Here we've got the emergency motion for immediate removal or to prohibit his arrest. So we have this or, so he's saying either is fine. You can either remove me to federal court or prohibit the arrest. Again, the court orders the DA to respond to his motion by Wednesday, August 23rd. Now that was the court order in response. He's saying, let me give the DA a chance to respond to what's going on here. In the interim, now that was document 20, so this is 21. Also, we had this order come down regarding the use of cellular telephones and electronic equipment. Now, I'll put it in pink if it's an order from the court, just to kind of keep our documents here in line. But it's said here we've got a local rule that allows for these kinds of devices and so on and technology to be used, but we have to see, because some are prohibited on the 19th floor of the federal building and the United States courthouse. So we got to keep that in mind here. It's allowed, but we have to be careful about where we're at. No, they didn't grant the motion. No, his motion was not granted as of this point. Right now, the furthest we've gotten has been a response. So that's where we're going to. That's where I was heading here, was this response from the government to his motion. So that's really where I want to spend more time, is going through and looking at the exhibits and looking at the state's argument, because she is setting out the argument as to why this shouldn't be in federal court also. So we have both of those pieces in here. Yeah, an Obama judge. I mean, it's a state judge. You have a response? Oh, well, that's funny. Oh, goodness. Yeah, racketeering, exactly. You've got 2 or more acts, you've got 3 or more people, and a common goal. He was chief of staff, according to, he was an executive branch person during the presidency. She was appointed by Obama. The judge is a man in this case. This is a dude that's a judge here. This dude, Timothy Batten, is that who you're talking about? Okay. All right. Well, whatever. I guess we'll just have to agree to disagree. I'm not looking for medical records. He's on the wrong case. He's thinking of DC. Okay, fair enough. Got it. Yeah, January 6th. Okay, yeah. It's a lot. Okay. Well, here we go. Let's dive in. I've noticed I need to be a little bit more careful because I think I've become a little bit more alert to the quantity of the negative comments. Like, I'm okay with the negative comments, but just the quantity has increased. So I'll have to make sure I keep myself in check here as best as I can. Okay, appointed by Bush. Fair enough. Oh, AC, are you banned or are you just muted? Okay, I gotcha. Yeah. Yeah, AC, the dog trainer, he's okay. Although everything goes by so fast here, I totally understand. I understand where we're at. Yep. Oh, thanks, Love the Wild. No need to be angry. Nope, no need to be angry. I agree. I think I'm just careful. I'm just a little bit more careful maybe, but I don't think it takes a bit more to get angry for me. Yeah, I know. So let's go ahead. Oh, that's so sweet of you to say, James. Thank you. Yes, I've had several. I finally got rid of all the sour apple ones. All right, let's dive in. This is a great response. This is the kind of response that I think every DA is like, let's do this. So here we've got him saying either move me to federal court or don't arrest me. Either way, asking the judge to do things that are really outside of the control of the judge. And here is her response. The defendant has moved this court for an emergency motion for immediate removal or order prohibiting the district attorney from arresting the defendant. Pursuant to this court's order, the state of Georgia by and through Fulton County District Attorney Fannie Willis responds that the defendant's motion is baseless and in direct contravention with the requirements of the law, which is exactly what we were talking about. The state respectfully asks that this court dismiss or deny the emergency motion as appropriate. Following a lengthy investigation, a Fulton County grand jury issued a true bill of indictment on August 14th against Mark Meadows, hereinafter the defendant, and others for violating the state of Georgia's racketeering statute and for soliciting a Georgia public official to violate his oath of office. On August 15th, the defendant filed a notice to remove his case to federal court. On August 16th, this court issued an order in accordance with this section of the code, directing the parties to participate in an evidentiary hearing concerning the defendant's notice of removal. Such hearing is to take place on Monday, so this is an important date here, at 10 a.m. Following the grand jury's return of a true bill of indictment against the defendant on August 14th, the district attorney stated she intended to provide the defendant 2 weeks to voluntarily surrender himself to Fulton County authorities. On August 21st, the defendant, through his attorney, requested that the surrender date offered by the district attorney be extended until next week. On August 22nd, the district attorney denied the defendant's request for additional time to surrender. The defendant then again requested that he be afforded additional time to surrender himself to authorities, which the district attorney declined to offer. So again, they're just going back and forth. Subsequently, on August 22nd, the defendant filed this emergency motion to immediately remove the case without an evidentiary hearing and to alternatively enjoin the district attorney from arresting or causing the arrest of the defendant. In his motion, the defendant contends that if this court does not either remove the defendant's case immediately or enjoin the district attorney from arresting or causing the arrest of the defendant, that the defendant will be subject to irreparable harm. And that the defendant will be arrested and otherwise subject to litigation in state court. Did he say pretty please? Oh my goodness. Oh my goodness. It's a lot. It's a lot. On August 22nd, this court entered an order directing the district attorney's office to respond to the defendant's emergency motion by 3 p.m., August 23rd. Accordingly, the state of Georgia submits this response. So here we go. The defendant's request for immediate removal is not authorized, and the court is required to conduct an evidentiary hearing. The defendant's contention the case should be immediately removed on the papers is meritless. Pursuant to this section of the code, the filing of a notice of removal of a criminal prosecution, quote, shall not prevent the state court in which such prosecution is pending from proceeding further, end quote. The only limitation imposed on the state court pending a notice of removal is that the state court may not enter a judgment of conviction before the prosecution is remanded. Additionally, if the district court does not order the summary remand of the prosecution, the court shall order an evidentiary hearing. Accordingly, the court is required to conduct an evidentiary hearing, and the state court is not precluded from proceeding against the defendant, even if his notice of removal is pending in federal court. So let's take a moment and digest that. He was saying, basically, we're going to get removed anyway, or this case is going to be dismissed, and so irreparable harm would be done if you arrest me in state court in the interim. And she's saying, that's not how the law works. That's what she's saying. That the state can still go on with what they're doing as they go forward. So just because something is pending removal doesn't mean that all state action needs to stop. The defendant's reliance on this case, for the suggestion that this court can permit removal without an evidentiary hearing is misplaced. Both of these cases were decided prior to the enactment of Section 1455. Accordingly, such authority does not provide any support for the defendant's contention that this court should dispense with an evidentiary hearing, or that the state prosecution should be precluded from proceeding against the defendant pending the court's ruling on the defendant's notice of removal. Again, she's just saying we still have to go forward even while we're waiting for removal. Next, additionally, this court, in compliance with Section 1455, has promptly ordered an evidentiary hearing to take place on August 28th, at which time both parties may be heard and present evidence concerning whether removal is proper. The court has also allowed the state until today, Wednesday, August 23rd, to file a written response to the defendant's notice of removal. That forthcoming response demonstrates that the defendant would not be entitled to any summary decision regarding the removal, even if such were possible under the law. The defendant's request to immediately remove the case is a not so subtle request to invite the court to improperly prevent the state from proceeding against the defendant pending the court's ruling on the notice of removal. Accordingly, the state of Georgia respectfully requests the court dismiss and or deny the defendant's motion in this respect as appropriate. This court should abstain from interfering in a state court criminal prosecution and refuse to enjoin or otherwise order the district attorney from performing her statutory duties. So this is a pretty big case, the pretty big argument that she's got here. She's saying the court does not have authority to take away her duty as a DA. The defendants request that this court enjoin the district attorney of Fulton County from taking action that would facilitate the arrest of the defendant is a request that this court violate the long-standing principles set forth by the United States Supreme Court in Younger v. Harris, requiring federal courts to abstain from interfering with or enjoining state prosecutions. In order to avoid abstention doctrine as it applies to state criminal prosecutions, the defendant bears the burden of demonstrating the proceeding against him was instituted in bad faith. This is a legal standard with a specific meaning, or that the proceedings are founded on clearly unconstitutional law. What's the difference between dismiss or deny? That's a good question, and it's because he's asking for two separate things in his emergency order. He is asking, let me just pull the exact phrasing up here. He's asking for a motion for immediate removal, which could be dismissed, and then the request for an injunction, which would be denied. So two specific requests, two different ways of answering that. Next, the defendant makes no such claims here, as has failed to make any showing his prosecution was instituted in bad faith or founded on unconstitutional laws. Instead, the defendant's principal contention, citing Younger, is that he will suffer irreparable loss by being required to defend himself in state criminal proceedings. The court in Younger, however, specifically said that the inconvenience of having to defend against a single criminal prosecution does not by itself constitute irreparable injury. That's a pretty significant point as well. In fact, federal courts have repeatedly denied requests to interfere in state criminal prosecutions. Generally, only in cases of proven harassment or prosecutions taken in bad faith without hope of obtaining a valid conviction is federal intervention against pending state prosecutions appropriate. That's under the Perez case. This one reversed the district court order suppressing evidence in a state prosecution and the return of seized material, and concluding the district court improperly intruded into the state's criminal process. Indeed, the propriety of arrests and admissibility of evidence in state criminal prosecutions are ordinarily matters to be resolved by state tribunals. So now we've got this push and pull here between federal and state, and she's setting out the case law to support where she's coming from here. The 11th Circuit recently affirmed the long-standing principle that injury merely incidental to a lawful criminal proceeding brought in good faith does not constitute the type of irreparable injury required to merit federal intervention. And I think that's really an important case to note, too, that he's saying, I'm going to be harmed if you pull me in. And she's saying, that's too bad. The courts have said, that's just part of the process. In essence, the defendant's emergency motion is a plea to this court to prevent the defendant from being arrested on the charges lawfully brought by the state of Georgia. Despite the defendant's attempt to characterize the request as a temporary pause, it is a request that the routine processing and handling of a criminal matter in the state system be dictated by federal authority. Such a request is improper. Here, the defendant does not allege that his prosecution is taken in bad faith, that there is no hope of obtaining a valid conviction, or that it's being taken to harass the defendant. The defendant is simply requesting that this court prevent him from being lawfully arrested as any criminal defendant would be after indictment on felony charges by a grand jury. The defendant's claim that his status as a former federal officer somehow heightens this routine procedure to the level of irreparable injury to the defendant is baseless. That's pretty concise, I think. Even if the defendant were under federal jurisdiction, the defendant would still be subject to arrest and detention. Further, other former federal officers, to include the former president of the United States, have agreed to voluntarily surrender to state authorities without the claim of irreparable injury. Additionally, the defendant's arrest will not preclude the defendant from asserting any state or federal defenses he may have. Accordingly, the defendant has failed to articulate the type of irreparable harm contemplated by Younger and its progeny. Okay, he's being booked right now. Are there cameras in there? I was wondering if they were going to have cameras available or not. Well, Teresa, I think it's interesting to hear the government's point of view here. Oh, for Meadows, yeah. Yeah, okay. Okay, there are cameras. Interesting. Uh-oh, I'm just making sure. Just making sure I'm in frame. Okay. Am I in frame okay still, everybody? I'm just double checking. Is this normal not to go to court? What do you mean? Which part not going to court? For Mr. Trump to not be going to court for his booking? Pretty intense news coverage. Okay. Just outside filming vehicles. Yeah, it looks good. Thank you so much, Katie. I appreciate that. Where did you find this? I can't find anyone by last name on Fulton County site. This one is, I found this on the docket. So what you would do is you would go put the state of Georgia versus Meadows, and you want to put in court documents PDF and do a search that way, and it'll pull up a couple of different sites. Yeah, he's at the jail. He's at the jail, which is different, in a different location than from the actual courthouse. So, yeah, he's just getting booked at this time. Yeah, it's okay. Did you, Mads, did you unblock him? That's okay. It's all right. Yeah, just see if you can unblock him. Our block should only last for a few minutes. So, sorry about that. Sometimes things get a little bit crazy. If everything blocked off. Okay, interesting. Yeah, interesting. No worries. Okay, yeah, I mean, we just, sometimes things just go a little bit, looks like every channel has it. Okay. So they're just, I mean, I'm wondering if there's cameras actually inside when they're doing the booking, because none of the other people had any of that seen. Like, I believe all of their arraignments, everything else, all of that will be online, but okay, good to know. Let me dive back in here. We're almost through this here, but I think, again, her arguments are really important for, this idea of whether or not it can be moved to federal court. No cameras inside. Okay, let's look at the bigger picture. State info used at federal level. Right. Personally, I think they should block bail bonds. That's interesting. Okay. Right. Well, and he's trying to claim, because he was a federal officer, he was a federal employee at the time of all of the charges, that this should be in federal court. And we do have a statute that allows for that. But in this case, we don't have enough evidence at this point to remove it to federal court, because he's not showing at this point yet that it was within his official duties. I am reading the government's response to his request for dismissal and for his asking of the DA to not arrest him. Of course, we know he went in, but, or he's going to go in, but he's not going to. Oh, good. I'm glad you found it. Yeah, there's lots of different sites depending on where you're at. All right, let me dive back in. The defendant also erroneously claims that the Anti-Injunction Act, which precludes a federal court from granting an injunction to state proceedings in state court, subject to limited exceptions, does not prevent this court from enjoining the state from arresting the defendant. The defendant appears to base this assertion on the fact he is seeking the court to enjoin the district attorney from acting and not the state court. Again, this is pretty significant. I mean, specifically asking the prosecutor to not arrest someone, that's pretty significant. It is the state court, however, that has issued the warrant for the defendant's arrest, not the district attorney. Georgia criminal procedure provides that a law enforcement officer may arrest a person for a crime with or without a warrant. Generally, it is typical Georgia criminal procedure for a defendant to be arrested on a grand jury warrant after being indicted. This generally takes place prior to or on or at arraignment, and is part of the state court proceedings against a criminal defendant in the state criminal justice system. Accordingly, the defendant's contention that the Anti-Injunction Act does not apply is meritless, and to enjoin such proceedings as this time is not authorized under the Anti-Injunction Act. Even as he makes the above argument, the defendant also seems to suggest that this act does apply, but the court's permitted to enjoin the district attorney pursuant to an exception to the act. And then she goes further into this act. Now, I won't spend more time reading because we're just talking about this specific act and that it doesn't apply. But let's bump down here to this injunctive release question. Similarly, the defendants claim that injunctive relief is appropriate to protect the defendant's right to removal, this is the key here, and the court's jurisdiction and orderly consideration of the pending notice is also meritless. Lawfully arresting the defendant on felony charges after allowing the defendant ample time to negotiate a surrender neither deprives the defendant of the ability to seek removal, nor does it impact this court's jurisdiction to consider removal. Arresting the defendant is simply the next step in the state's criminal process against the defendant, a process that, pursuant to this code section, does not pause pending the court's ruling on the defendant's notice of removal. So, oh, hi, CJ. That's okay. That's okay. We're really just kind of getting into it here. Further, and again, we're almost at the very end. This is her final piece before her prayer. Further, even assuming that the court grants the defendant's motion to remove his case to federal court, the prosecution against the defendant remains, and the defendant is still subject to arrest and detention for the offenses for which he has been indicted. Accordingly, the defendant's request to enjoin the district attorney from arresting or causing to have the defendant arrested is futile, and the court should dismiss or deny the defendant's motion in this respect as appropriate. Then she comes in for her prayer, or the conclusion, which is what she's asking the court to do again. So she will just go back and reference what she's already said, and then asking the court to dismiss or deny. So that was her piece. Now, as this is document 23, so that takes us then to document 26. Which is removal again, the indictment as well. Now, we've got the court. Oh my gosh, this is also very interesting legally. This matter appears before the court on an amicus curiae motion for leave to file a brief in support. We have someone here who's trying to file a amicus curiae brief to support his emergency motion to get out. And the court is denying this. Again, this is absolutely unheard of. We have another legal scholar coming in order to try to persuade the court to issue this emergency order. Am I off center? Sorry. I do rely on the comments to make sure that I'm in frame, so I appreciate you telling me. I'm glad you told me. How's that? How are we? I'll wait until I see. Are we good? Okay, good. I'm glad you told me. No, it doesn't. Yeah, you just let me know. Just let me know. It's no problem. We're all a little bit off center. Yes, I had the tape, but then the tape kind of, it's complicated. All right, now we've got document 27. Now remember, the document I just went through was the state's response to his emergency motion, where he said you need to toss this or not file it. Oh, explain amicus real quick. Sure, an amicus curiae or amicus, depending on who you talk to. I think Latin's really not meant to be spoken. That's just my opinion. But when we have a complicated case, typically like the U.S. Supreme Court, and you have experts in the field that know a particular complicated issues in front of the court, they'll prepare a brief to try to explain to the court the legal issues or other issues that are involved. For example, like in the Dobbs case, I think there were like at least 80 amicus briefs, maybe upwards of 200. I can't remember the exact number. But all of these different briefs can be brought in order to help the court make their decision. But to have a motion on a state criminal case trying to ask the DA to not arrest him and have someone coming in saying, hey, I want to file this brief to support his emergency motion, unheard of, absolutely unheard of. I've never seen this before. It's fascinating. Oh, hello, Tara. Very interesting. So yes, amicus curiae, it just means friend of the court. It's an outside person, not a party to the case, who's trying to file a brief to help the court make their decision. Usually it's the U.S. Supreme Court making a decision on a major constitutional law question. Here we have a court on a motion for dismissal. It's just absolutely fascinating. There you have it. There's amicus. Now we've got onto document 27. Is it under seal? Who filed it? It's not under seal. Let me pull it up here. This is just to be clear. Let me cite my source. This is document 26. And I did not pull the actual brief. It was by Cynthia Alksny, Erwin Chemerinsky, Amy Copeland, Julie Grofluski, Sarah Sullivan, Sean Wu. It looks like, and it was a brief of amicus curiae in opposition to the emergency motion. And then we also, that's the other one. Hold on, let me double check. I've got so many motions here. Motion for leave to file a brief as amicus curiae with a brief in support by these people, right? And then we've got a brief of amicus curiae in opposition. So we've got two briefs, one in support and one in opposition. There you go. My goodness, that's a lot. Anyway, they're denied. No briefs, no amicus curiae briefs on a motion in state court. What? Oh my gosh, it's a lot. It's a lot. And it's a bit disappointing in my humble opinion because we've got Erwin Chemerinsky, and if anyone knows constitutional law, he's one of the, I guess, grandfathers of constitutional law issues. So I'm not sure why he would be involved in this case, but anyway, all right, here we go. Hillary's still lost. Oh my goodness. Oh my goodness. All right, back we go. Now we've got, so no amicus briefs, which again, it's just crazy to me. We've got document 27. She's coming in and she's saying, by the way, your removal to federal court's inappropriate. And she goes into her explanation. And I think it's important to note a couple of her big pieces. So I'm just going to pull out the highlights here, primarily because I want to get into her exhibits, which I think are really interesting. We've got the defendant is asking the court to remove this case to federal court because he's facing charges that do not arise. She's saying they do not arise under the conduct under the color of his office. And because he can offer no plausible federal defense, the state of Georgia respectfully requests this court remand the case to the Superior Court in Fulton. Now, she explains quite a bit here on why he was not within his duties as chief of staff. Here's what she says. The defendant is the former chief of staff. Now, I'm not going to read everything here, but there are a couple of highlights here. to the President of the United States, and his lack of care for the lawful scope of his official duties is a matter of record. Ouch. All right. There's number one. There's one ding. Federal law prohibits employees of the executive branch from engaging in political activity in the course of their work. The law in question, known as the Hatch Act, bars a federal employee from using his official authority or influence for the purpose of interfering with or affecting the result of an election. So she comes in right out the gate and says he violated the Hatch Act, and that's it. So, and she cites a particular report. Now, if you were with me earlier today, I did go live just briefly to explain this particular exhibit. And I wanted to bring this to everybody's attention here. Again, this is another document that's online that's part of this whole situation. Exhibit D is a November 9th of 2021 report from the U.S. Office of Special Counsel. This report set out huge violations of the Hatch Act under the Trump administration. It's huge. They go into great detail and specifically set out these people who were executive officers and specific instances when they violated federal law. I think it's really interesting to know what's going on here. So we've got the Secretary of Energy, Dan Brulette, Senior Counselor to the President, Kellyanne Conway, White House Director of Strategic Communications, Alyssa Farah, U.S. Ambassador to Israel, David Friedman, Senior Advisor to the President, Jared Kushner, White House Press Secretary, Kellyanne McEnany, White House Chief of Staff, Mark Meadows, which is the key that we're looking at here. These are all of the people that worked in the executive branch that had findings of violations of the Hatch Act. These are the listed people. Senior Advisor to the President for Policy, Stephen Miller, White House Deputy Press Secretary, Brian Morgenstern, National Security Advisor, Robert O'Brien, Chief of Staff to the Vice President, Mark Short. And then they set out the analysis of all of the times and places where these different people violated the Hatch Act. Okay? Yes. Now, what's so great, what's so interesting about this report that is now public, this was done in 2021. So when there are questions of, when did the investigation start? It started a long time ago. But what came out of this report in the end was all of these findings of violation of federal law. But because of how the law was written, there was no way to hold any of them accountable. Because the way the law was written, it stated that they had to tell the president, and then the president had to admonish them and tell them not to do it and hold them accountable. And the president at the time refused to do that. Y'all crashed it? It's the Fulton County Jail website. Oh my goodness. Oh my goodness. Oh, I love that. I just love that so many people are so interested in criminal law these days. I just think that's great. I am all about that. Whatever means we need to have in order to learn more about the law, I think that's just fabulous. Hopefully it'll be back up soon. People want to see the picture. You've been on it all day. Oh my goodness. Oh my gosh. I'm sure it'll be up. I'm sure it'll be up and around. It's more exciting than real estate law. Well, I'm not sure. I'm not sure how much that would take, but fair enough. It was close to going down. Oh my goodness. It's more exciting than real estate. It only takes America's dumbest criminals to draw us in. Oh, I love it. No, that's great. Once something like this actually has an influence or affects your life, that's when you start, wow, this is interesting. So, that's fascinating. I hope it comes back up for everybody. Mugshot won't be posted until tomorrow at 4 p.m. Oh no, Renee, no. That's interesting. I thought everybody's mugshots were posted pretty quick. Family law, yeah, that's tough. It's definitely tough. Yes. Yeah, it's a very, this is a hot topic. for everybody involved. Normal people don't break the law. It's true. I mean, it's very true. And most of the laws that get broken are minor offenses. We don't usually see crimes of this level regularly. We just don't. Not treating him like every other defendant. Yeah, I'm not sure. I'm wondering what's happening there. I'm not sure. I don't think the mugshots are okay. Yeah. So if you're right, let me take you back. Let me take you back in here. Oh yes, it's a lot. Let me take you back into what I was talking about here that came out that I think is relevant. I think it's important. So the office of the special counsel here was called in right after the election. And they were called in because there were questions regarding statements that had been made that were violations of the Hatch Act. The Hatch Act is a federal law that makes it illegal for people who are federal employees to actively campaign under the color of their positions, under their jobs. So they make it's illegal to do that. They found all of these people violated the Hatch Act, all of them, every single one of them. I mean, some of them I've heard of, like Kellyanne Conway, David Kushner, Mark Meadows, Stephen Miller, all of these people found to have violations. But unfortunately, what happened was the statute had holes in it. The problems with the statute made it so that in order to, even though the statute was set out in the 30s, in order to hold anybody accountable, they would tell the president, like, hey, president, some of your people are messing up. And the president would be like, okay, and go tell the people, and the people would stop doing it. Except for this president. They talked to this president, and they said to this president, your people are violating the federal law. And this president said, I don't care. And there was no way to go forward and enforce the law because of how it was written. So in this particular report, they set out all of the problems with the Hatch Act in being able to enforce it and suggestions on how to clean it up by making different changes to the statutes. Yeah, it was a really big deal. And what's so interesting here also is that the only reason why this was really brought in to everyone's attention was because there was a statement that had been made right after the 2020 election. And they say here, let me just find it. Of course, we had the RNC question about whether or not that could be held at the White House and the implications. But we've also got this question to President Trump was asked about the Hatch Act implications using the White House as a venue for the Republican National Convention. He said there is no Hatch Act because it doesn't pertain to the president, which is true. Sure, this is a document that is a report from special counsel regarding violations of the Hatch Act during the 2020 presidential election. So all of the people that were part of the executive branch that are listed in here, all were found to have violated federal law because of statements they made to the media and on different shows that they went on. And their comments were violations of the Hatch Act, but they weren't held accountable. None of them were held accountable because there wasn't a good mechanism in place because of how the act was written. So we had a technicality that kept all of these people from being held accountable. It's a good question. And there's a big question because it has to do a lot with how tax money was being spent as well. Now, we've got a press conference going on here for the Hatch Act, but we've got a specific quote I wanted to show you that is just what's so relevant to Mr. Meadows. Let me just make sure here I find it. I had highlighted it before, but then I had to reprint. So there were all of these very negative comments made about Biden during the election. There were negative comments made about Obama. And essentially, Mr. Meadows came in and said that there is really no Hatch Act, that nobody in the Beltway follows the Hatch Act. And so because of that, they all just went forward and continued to violate it. Just double check here. Right. So mostly the report are all of these negative comments that were made against the other side. And going into the fact that it was unenforceable, which is one of those moments where we realize the law isn't working correctly. Right. Okay, so advice to executive branch agencies in the past. The Hatch Act does not prohibit agencies from defending and appears to have been interpreted in a way that allowed senior agency officials to engage in political activity under the guise of defending the Trump administration's policy positions. So one of the biggest problems was they actually changed some of the wording in order to make different people allowed to say different political responses. Yeah, it's a huge issue. It was a huge issue. Yeah, and the big issue, again, we don't have a mechanism for enforcing the Hatch Act. So we have a violation of federal law, but no way to enforce it. So that, I think, is a fundamental legal structural issue that went on. Fascinating, again. We've got people involved, and in particular, we have Mr. Meadows involved, and he's stating, I did everything under my official duty, but yet his official duty would be a violation of the Hatch Act if it had to do with political stuff, if you're following me here. Political stuff, political campaigning. That's the technical term, political stuff. Here's his specific section that he set out. And these are just disparaging comments that he made against various people that they were campaigning against. And all of these comments were violations of the Hatch Act. Yep. So I think that's really important. I wanted to kind of bring that to everybody's attention. This is available for everyone to take a look at. The comments, the things that were said are really, really pretty awful. So if you're interested, you can take a look at that. But let's move on then to our other exhibits. I do have a video of that posted up on my Tube of You channel for anyone who would like to actually see the details of what was said and done that violated the act. Now, let me pull myself back into the correct format. Am I in frame okay? Before I move on to the next exhibits, no rule of law. Much appreciated. Oh, absolutely. Go for it. Go for it. It's a fascinating read. Okay, good. It's a fascinating read to take some time and see how each one of those people violated federal law repeatedly, but there was no way to charge them with an offense. Now, she goes in, I'm back here to Fanny's explanation of why this shouldn't go to federal court. All right, so we're back into her motion. And explaining again that the defendant was not acting under color of office, explaining again that this violation of the Hatch Act was not permissible. And even though it was allowed under the president, unquestionable political activity was allowed, doesn't mean that it wasn't a violation of the law. So she goes further into that. That's really what the majority of her response is. And she'll take this argument all the way to the end. His mugshot is up. Okay, well, that's good. I was going to say, I didn't think it would take that long for it to come up. And then the very last page again, we have this conclusion. He has no basis in order to have this removed to federal court. And it's pretty significant language that she's included in her order here. Let me flip to page 21. The defendant has been indicted for joining a common plan to overturn a lawful election and for asking the state official to violate his oath of office by altering election returns. So those are Meadows' 2 counts. His indictment is the result of activities taken by him solely to advance the personal and electoral interests of Donald J. Trump. He can point to no legal basis authorizing his actions as part of his official duties as chief of staff, and he does not even attempt to explain how his activities could be lawful under the Hatch Act. The defendant's actions were not made under color of his office and do not support a claim of Supremacy Clause immunity. Instead, they demonstrate his characteristic disregard for the proper scope of his duties as a federal official. For all of these reasons, the state of Georgia respectfully request that this court find the removal should not be permitted. And so there is her argument against the removal to federal court. And then she's got further exhibits as well. We have a deposition that's Exhibit A. We have another deposition of Ms. Hutchinson, which is Exhibit B. And then we have a deposition of Mr. McEntee, which is Exhibit C. So that supports her motion. Yes, it's fascinating. I mean, it's rough. The whole situation is absolutely everyone should be talking about it. One way or the other, we should be talking about it. So that's what I've got for paperwork. I really wanted to kind of open things up to get a Q&A going on what questions people have. We've got a lot of documents that have been coming through. We have a lot of different procedures that have been coming down. So I'll just open up the floor and we can just ask away here. You know, sometimes, oh, did I mute you? I don't think I was on yesterday. Was I? No, I wasn't. I joined for the debate. I joined another creator. Oh, thank you, Katrina. Thank you. I do try. We do talk about a lot of things here. I think probably one of the biggest questions I've been getting almost constantly now is the question of the 14th Amendment. So, of course, that's been a big one. Firstly, thank you, and the mods. Yes, they do great. They do great work. What do you think of the trial that's set for October 23rd? I think she's ready to go. I think she is absolutely ready to go. I think he's pulling a power play. That's typically what we would call it when a defendant's asking for speedy. And the judge is like, fine, let's do it. So I think I wouldn't be surprised if he revoked or if he waived speedy as we got closer. But I think she's ready. I think she's definitely ready to go if she needs to. Absolutely. Is there any legal cases similar to this? Absolutely not. I mean, there's tons of RICO cases all over the place. Absolutely, sure. But something of this scale with this many states and this many co-defendants, oh my goodness, I've never seen anything like it. Nope. Do you think they'll have a hard time finding a jury? I think any of our high level cases, they're going to struggle, but we'll still find one. I think it will just take more time. It'll take more patience, but we will always find a jury. We always will. Regarding the Hatch Act, would they have to charge differently for those violations? The problem is in the language of how the Hatch Act is actually written. So there isn't a way to go about an actual formal criminal charge because of how it's written. And that's one of the things that the special counsel was asking. They're saying we need to change the language in the statute to put a better mechanism into place. So at this point, there was no way to charge them going forward. What's the longest time it's taken to find a jury for any case? I don't really know. I don't know. You know, it's all about the things that take the most time is if you go through your entire pool that's been brought in for that first session. If you go through everyone and you can't find enough people, then we have to call more people in, and that takes more time. Although, you know, we've got batches of jurors kind of waiting in the wings, so it doesn't take really that much time, but it can slow things down a little bit. Thank you for putting these up on YouTube. Oh, I'm so glad that's helpful for you. I'm so glad to hear that. How long will a trial be? I don't know. I mean, these RICO cases are complicated, but with this DA, I mean, she's setting everything up and kind of knocking it down. I mean, she's ready to go. So I'm not really sure. Can you explain what the Hatch Act is again? Sure. The Hatch Act was a federal act that was passed in the 30s. And the point of it was, the intent behind the act was so that people couldn't use their positions as federal government employees in order to persuade people to vote a certain way. So for political campaigning, essentially. typically the act is used if a federal employee puts up like a political poster or some kind of wears a hat during a meeting, or has different paraphernalia around of different candidates. They can get dinged on it. But the bottom line is that you're not supposed to be wearing your uniform or being in your official capacity and supporting a particular candidate, because it gives an extra kind of credibility to that particular candidate because of your role as a federal employee. So the act is set into place to prohibit that kind of action. So we've got a whole bunch of people here who are official federal employees who are saying vote for this particular person, or don't vote for this other person. And so those are clear violations of the Hatch Act. Rudy's going to get immunity? Maybe. Merrick Garland invoked DOJ battle. Triple K to set the tone for... Oh. How do you find jurors? Are these people been... the thing about finding a juror is, they don't have to have a complete lack of any knowledge of what's going on. They don't have to have never heard of the situation. What we're looking for is a juror that can be fair and impartial. Sometimes that can just mean they've heard a little bit, but they haven't paid attention, or, they're busy in their own lives and they've got life to live and they've not really focused on it. Another one could be like, I've heard of it, but, I'm undecided. I haven't decided. I need to see the evidence before I make my decision. And so it's okay for them to have knowledge. It's just they need to be fair and impartial. That's the key. That's what we're looking for. Why would the supremacy not apply if he was acting outside the official duties by violating the Hatch? Okay, wait. Why would supremacy clause not apply if he was acting outside? The supremacy clause, I think he's trying to say the Constitution is the supreme law of the land, which is the supremacy clause. And so he's saying, because of my official duties as part of the executive branch, I was doing what I needed to do. But if he's saying he was doing what he needed to do, he was also then admitting to violating the Hatch Act with his political speeches and things that he was saying. So he's violating federal law. So he can say, I was doing it under, my duty under the executive branch. But by saying that, he's saying he violated federal law. So either road he goes down, he is violating a law. And that way, immunities will not attach if you're violating the law. How much time? I'm not sure. I think it's 5 years minimum, up to 20 for the racketeering. And then for each charge, he's only charged with one more charge here for 28. I'm not really sure how many years he's got for that one. Will the fact that the DA is under investigation from Congress set back the trial? She's not. I don't have any information about that. Is there a time limit for jury deliberations? No, I don't think so. We get to a point where our juries can hit a wall, but judges are so sensitive to that. They're like, wow, are you hitting a wall? What's going on? What do we need to do? Because at some point we have to just call it. And that's, we could have a hung jury. You got to do what you got to do is not a valid defense. Yeah, true. I know, right? I know. Just like liar, liar, pants on fire. Yep. Not official. It's not official, but we can try to sneak it in. Can they try him in federal court alone? It looks like he's attempting to, but it's not looking very successful based off of what she just filed for her response and the judge in the situation. It's definitely not. Yep. I think office holders who took a deal will be forced to step down. That's a really good question. I'm not sure. That's a great question. I don't know, Jeffrey. Excellent question. Let's see. When will they bring up the 14th Amendment, Section 3 and try to stop him? Okay, good question, Becky. Excellent question. So, we've been talking a little bit about that. We've been going into Section 3 of the 14th Amendment on my channel. It's a hot topic that everyone is very interested in. And the here's the question. Here's what I would ask you, everyone here. Here's the question. We have a section here of the 14th Amendment that's saying, look, you're not allowed to hold this position. Now, if we look into the Constitution, we have a section. Let me just show it to you here. You don't have to take my word for it. Let me just show you the goods. We've got under, let me just make sure. Let me see. Under Article 2, we have, okay, here we go. Here's the sentence. No, nor person except a natural-born citizen or citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and have been 14 years a resident within the United States. Here's my question I would pose to you. You've got to be 35 in order to run for president, right? Who enforces that? Who makes sure that you're 35 in order to run? Who's in charge of that to make sure that you are a citizen under the rules under Article 2 and that you're 35? Who's in charge of it? Right. Secretary of State, right? Right. So what happens if you are 30 years old and you are trying to become president? What happens? You didn't know there'd be a quiz? No, I'm just like, let's talk it through. I guess what I'm trying to say is like, let's talk it through. How would you, what would happen? What would be the process? Oh, thanks. Thank you. Right, you don't get on the ballot. But how do you not get on the ballot? If you're 30 and you are trying to run for president, how do you get kept from the ballot? You wouldn't be nominated. You're blocked. Right. You couldn't run. Right. The Secretary of State. Exactly. Because you're 30 years old. You wouldn't qualify. Exactly. So here's the deal. If you don't qualify because you're 30, then if you look at this language and it says you shall have engaged in insurrection or rebellion against the same, you are disqualified from running. So who would enforce this disqualification? Free humanity, that's not true. Yeah, that's right. Whoever is in charge of making sure that the qualifications are set out for the candidates is the one who would decide whether or not they're disqualified under this section of the Constitution. That's the legal argument. No, is this right? I mean, who puts you on the ballot? Like if I just went up and said, hey, put me on the ballot and I want to run for president, and let's just say hypothetically I'm 30, how would I be prevented from doing that? Who would stop me from doing that? Right. Yes, because they're the ones in charge, right? My mom would definitely be supporting me. She'd forge the documents. Hi, Mom. No, this is before you're even on the ballot. Who prepares the ballots? You have to have a certain number of signatures, right? In order to run, in order to get nominated, in order to go forward and put yourself into different positions. You have to be a citizen for a certain period of time. You have to be a certain age in order to run for the House of Representatives, in order to run for the Senate. You have to be a certain age to be governor. Who's in charge of making sure those qualifications are all in place before you're put on the ballot and other people can vote for you? Because you are vetted before your name goes on the ballot. And if you don't qualify, you can't be put on the ballot. Because if you go on the ballot and you don't qualify, and for some reason you are elected, you're disqualified. Right. Right. Those are the questions that you have to ask. Right. Who is in charge of making sure the candidates meet the qualifications to run? Those are the questions. And it's going to depend on your state. What's the right answer? I can't. I will leave this up to you to decide. In my jurisdiction, I know who is in charge, but I leave it up to you. I leave it up to you. Figure out who is in charge of putting your candidates together and making sure they have the proper qualifications. Somebody at the DMV. Oh my goodness. I Googled it in this Electoral College. Now, the Electoral College means we have to choose our electors, right? Well, how do we choose our electors? It's left up to the states how they choose the electors. We choose in my state, and almost, I think every state, choose based off of whoever gets the majority of the popular vote. Our entire batch of electors go to that president candidate, right? So in order to put your name in to be part of that popular vote, how do you get your name on the ballot? Right. Right. It will depend on your state. So I challenge all of you. I challenge all of you. Look it up. Look it up. We're not dealing with necessarily convictions here. We don't have conviction language included. Conviction language is included in other parts of the Constitution, but not here. Can we talk about how he fired his top attorney today? What will that do to defense? Oh, I don't know. I hadn't heard that. Bob Dole puts the names on ballots. State Board of Elections. Okay. Some states make it harder than others. That's the trick of it. It depends on your state. We've got 50 states plus our territories. We've got all different kinds of different ways that people qualify and have to run through the process in order to get their names put on the ballot. You have to figure it out for your particular state. It's true, Congress can vote by 2/3 of each house to remove the disability. And look at our Congress. Is our Congress going to remove that disability? That's a good question. I highly doubt it. 35 is to run. Yes, but that's the question though, isn't it? If it's a qualification issue, if that's the issue, if someone's disqualified from running, who makes that determination? Yes, let's eat chicken. I'll leave you with that question when it comes to the 14th Amendment, because that's really what it comes down to. It's a qualification. Right. But does it need to go to the court right off the bat? And when it comes to age, that's pretty well known because it's specified. But when we're using this language, shall have engaged, that language may need some interpretation. That's what could put it in front of a court. Congress has the right to enforce at the end. Doesn't that mean they have to vote? Yes, they would have to vote. They may, by a vote of 2/3, remove the disability. They don't have to. They don't even have to have a vote. They don't even have to bring it up because of the word may. Right. They do not have to vote. No, they may vote if they want. And by 2/3, they can remove the disability. That is absolutely possible. Right. And we have the Supreme Court, and they would look into this language. But when you're talking about this Supreme Court and the actual language of the Constitution, now we have to look into how have they looked at all of the other parts of the 14th Amendment with that plain language. Yep. Yeah. I mean, it's a thinker. An upper age limit. I would vote for that. I wouldn't be against that. So when would it be brought up? Great question, Becky. So here's the deal. if someone was to come in with their paperwork and give it to whomever is in charge of qualifications, and the person is obviously a government actor, a government person, and they said, I'm sorry, sir, but you do not meet the qualifications to be on our ballot. You are 30, you're supposed to be 35. Let's just use that as an example. And that person says, well, I'm actually 35, and argues with that government employee. That person would have to sue that government employee in order to prove they were actually 35 and not 30 in order to force their names onto the ballot. Listen, dude, we don't, oh, psh, God. He's gone. Oh, God. You know, may does have a lot, but the one thing we do know that may means is that it does not mean shall. That's what we do know. The Secretary of State has to decide if they qualify in Indiana. There you go. Now we know then, Kathleen, for your state. You got it. You got it. Whoever wins the party primaries is automatically on the ballot. No, how do you get on the ballot for the primary? Right. Can you even run for a primary if you're not qualified? Can you run for a primary for president if you're 30 instead of 35? I haven't had a chance to look into it yet, Travis, but it's on my list. I have a sticky note attached to my computer. There's been no conviction, true, but a conviction is not required under this language of Section 3 of the 14th Amendment. A conviction has been listed under things in other parts of the Constitution, so conviction can be used, but it's not used in this section. In this section, it just says, shall have engaged. It does not say, shall have been convicted. Yes, I've got, my sticky note. I've got to look at that. Even if I qualified, I can't run very fast. Well, fair enough. Burden of proof is on the 30 to 35-year-old, not the state official. That's correct, Laura. You got it. The state official is saying, the evidence I have shows you're 30. The other person is saying, no, I'm 35. That person will have to prove it. It's their burden. They're the ones that would have to take it to court in order to get their name on the ballot. You're welcome. You're welcome. Absolutely. Yes, shall versus will. And may. Yep. Let us know. Scary stuff. I will, Travis. I will. It's on my list. I've heard several people now bring that up, and I think it's something very interesting to take a look at. But absolutely. What is all state officials think that they're 35, and on a day before swearing in, they find out they're 30? Well, that's a little different issue. Because now we've got different people involved. But if we've got somebody placed on a ballot that wasn't qualified and everything goes through, and who do you think then would contest the situation if they won but should have been disqualified? Who would bring that lawsuit? The person who lost, right? So if you won but should have been disqualified, the person you beat would be upset and would have been harmed and would bring the lawsuit because you were disqualified and should not have been on the ballot. Exactly. The opponent. Yeah, exactly. You got it. So now we've got another route. So we've got a couple of roads we can go down depending on the situation. What about Santis? I don't know. I saw some memes of him going around with that scary guy from The Boys, I think, was it? Is that the name of the show? That was some scary stuff. I remember the hanging chads. We all try to forget. Couldn't a supporter of the losing opponent also bring the case? You would have to show a personal harm. So we have a particular case, great question, and it's the Lujan case, where in order to have standing, you have to show that it has personally affected you. So it would have to be, it would have to be pretty well stated. Do all 50 states have to agree on Section 3? All states have sovereignty, right? So All states have their own way of going about their electors. They have their own law, the electors law in each state, and how people get on the ballot and the protocol, the procedures, those are all set out by states. And each state does it a little bit differently. So depending on the state, you could have a state where they say, you don't qualify, we think you're 30, so we're not going to put you on the ballot. And you could have another state that says, I think you're fine. But now we've got this issue where this particular person is not on all the ballots. But if you have a state that says this person is 30, not 35, all the other states are going to take a look and investigate and make that decision. But half the states allow them on the ballot, half the states don't. What's going to happen then? That's the ultimate question, because now you're going to have states fighting each other saying, we've got proof that this person's 30 versus the other state that says they're 35. But now each state, because of their own electoral or their own election laws, have to do what they have to do for their state. It gets deep, doesn't it? I know, Becky. It's not an easy question. It's because it's got so many levels to it. The electoral count decides. Ultimately, it does. That's exactly it. At the end of the day, when it comes down to it, the way the Constitution is written, because of the 12th Amendment, the Electoral College decides who wins. So if for some reason someone is not on a ballot in a state, they would not receive the electoral votes for that state. But they could technically receive electoral votes for the other states that they were actually on the ballots for. But yet you still need to get to, 270? Is that right? Is that the number? Let me double check that. $270. Yep, $270. Thank you so much. Yeah. So you still would need $270. And that would be more difficult to get to if your name wasn't on ballots. I think Georgia was the worst state a person could get indicted in. Honestly, Robin, I do. I really, really do. With this DA and her RICO background, oh my gosh. That was a tough break, I think. Yeah, Sweets, you're not alone. I think we all get flashbacks from that. Oh, he does. We'll tell him I said hello back. And that, it's a great road to go down, although the paralegal road is also fantastic. Highly encouraged as well. It's an amazing road. That's wonderful. I love to hear that. Yeah, it kind of is Jilly Bean. It kind of is karma. It kind of is. I'm just saying. It's just the break America needs. It's, it really does emphasize how important each state's rules are when it comes to voting and what the protocols are. We have to find it. Paralegals represent. Yes. Oh, we love the paralegals. We have to have it. Just turned 9. He's good at negotiating. Oh my gosh, I love that. Well, he might go for the FBI then. We should commemorate the 250th anniversary of the Constitution by rewriting it. A lot of people feel that way. I wish we could somehow get an agreement on something so that we could get something done. That would be good. His mugshot's already on TikTok. Oh my goodness. It goes fast. It goes really fast, I think. Wow. That was fast. That was very fast. Yikes. Yes. Yeah, it's complicated. It's complicated. Oh, okay. To have serial numbers on the ballots would be advantageous. Oh, that's a good idea. I think some kind of continuity would be good, but I think also our states just don't want to agree on anything. Like, we just don't even agree on what to call our prosecutors. Like, even the basics. Even the basics, yeah, nobody will agree on. It's a pumpkin spice day and mugshot day. Oh my gosh. It's so hot in my area. We're not there yet. We're not quite in the spiced pumpkin spice yet. I'm waiting though. I'm ready. Wasn't Matlock based in Georgia? I think you're right, Jim. I think he was. Okay. It's up on CNN. Yeah, I mean, this is way too hot. Yeah, I agree, Jess. I agree. There's a lot of mugshots going on. Is out today. Oh, I'm not ready. It's too hot. Coffee shop sells alcohol. Oh, nice. Oh, my goodness. Accusations are not proof of a claim. You are absolutely correct. Yes, all year round. There are some flavors that are just all year round for sure. I'm with you on that. Oh, I really I don't wish anyone any ill will when it comes to, the criminal justice process. It's traumatic for everybody. It really is. It's hard. It's hard on everyone. That's what it shows on CNN. Okay. Interesting. Yeah, 5 years minimum for RICO. You got it. Cinnamon's good all the time. I agree. Cinnamon coffee and chocolate and cinnamon. I'm all about that. I'm okay with that. I'm not sure about the pumpkin part all the time, but I would vote for that. I would vote for cinnamon all year. For sure. Steady trying to find the... Yeah, cinnamon and chocolate. I love it. I can't help it. Will they all go to court at the same time? No, I think their arraignments, and it's going to be interesting. I'm not sure how it's actually going to work because we're dealing with felonies. And so, they're going to need to come into court, although sometimes we do written arraignments, but I don't think written arraignments would be applicable here. I really just don't know Georgia law that well, but they are each individually going to need to make their arraignments. So each one will come in and plead not guilty separately. They wouldn't do it as a group where we're raising hands, like the debate last night. They wouldn't be like that. They would have to each individually plead and make their arraignments go. Power the legislature is given itself to remove district attorneys. I'm not sure what's going on with that in Georgia. I'm not sure. I have not looked too far into that, but they've got a couple of interesting criminal procedure rules down there that are just a little bit different. If you plead guilty to RICO charges, 5 years minimum. Yeah, 5 years minimum, 5 to 20, which is, of course, a huge range. But when you've got mandatory minimum sentences, it means the judge, the DA, nobody can do it. It's set by statute. It's set by the legislature. So no matter what happens, if you plead guilty, you're going to get at least 5 years. Now, you might only serve 2.5. I'm not sure how Georgia works, but you would have that sentence set out as a mandatory minimum. That the trial process would take years. Any opinion on time? It's an excellent point. With these RICO cases, they're so complicated. There's so much involved in them. So it seems like it would take a really long time, but again, we've got speedy at play, although I think it'll get waived. So I'm not sure, but we've got pretty strict rules regarding how long you've got in order to get a case through. But I'm not sure because Georgia has these unique pieces when it comes to their RICO laws. And sometimes it takes longer, and they allow for it. I think it's written in as part of their law. Will we ever find out who pled and the details? Yes, absolutely. All of that information will be made public eventually. It'll take some time, though. It'll take some time for that info to come out. Someone's asked for speedy trial. Right, Cheeseborough. Cheeseborough, I think is this one here. This fella. He's asked for speedy. Looks like it's going to go to October. Not to be confused with Meadows, who was asking for it to be moved to federal court. Right. Beginning October 1st, Legislative Commission has the power to remove the DA. That's really interesting. I'm not sure how that's going to come down. Cheeseburger. Oh my goodness. Hope there's no cash. Oh my goodness. Has been under indictment for 8 years, fighting to run the clock out. Interesting. Okay. Interesting. I have to take a look at that. Did Meadows' removal get ruled on? No, it's not gotten ruled on. The DA just responded to the removal yesterday. She just filed her response. So the judge hasn't ruled on it as of yet. Oh, well, yes, Johnny, I'm glad you could stop by and hang out with us for a little bit. Won't one case decision affect the other? It's possible, but there's such a mixed bag. I think it depends on which case it is. I mean, for example, like Miss Ella, she's got counts 1 and 2, but meanwhile, Cheesebro, he's got a whole bunch. So I think it depends. I think these two together, Giuliani and Trump, they've got a lot of, and Eastman, they've got a lot of similar cases. So I think they could, affect each other, but I'm not really sure. I think it'll depend on how many times they overlap. Well, yeah. Mm-hmm. Yep. Mm-hmm. Is that Rescue Cats? Is that the mug shot? Do you already have that? Oh my goodness. He looks pretty. Oh my goodness. Oh my gosh. Can I talk about the guy who did not make bail is being held? I didn't know. Oh my gosh. That you're quick. You're real quick. I didn't know that someone didn't make bail as of today. Do we have a name for who it is? Do we have the name? Can't evidence admitted for one defendant be used for the other defendant? Well, getting complicated here because we've got this fella who's asking for a speedy trial. So number 5 is asking for speedy. So his case may go on its own, which means all of the other ones, she had said she wanted to try them all together, which makes sense. So she's only putting on one RICO case and then separate counts. But if she tries all the rest of them together, we could have 2. We could have one for number 5, and then we could have one for the rest of them. It's going to depend. But all of the evidence will be like a fresh start for every single person. So you're not going to, you can have essentially like a practice run with that first trial to figure out what works and what doesn't work. But it'll all be brand new and fresh each time we go in. Harrison Floyd. Okay. He might have been, was he one of the, let me see. Okay. He might have been one of the locals. Oh dear. It says here the defendant in the Georgia case allegedly assaulted an FBI agent who tried to serve him a subpoena, but I do not have any corroboration for that. The answer is he didn't have a prearranged bond. Okay, so he's the only one that didn't have a prearranged bond, it looks like. Am I catching that? Yeah, Georgia law, they set out when speedy needs to be done. Mm-hmm. Yep. Okay. Yep. Right. So it looks like he didn't have a prearranged bail agreement. So he is in jail. It crashed at one point. Yes. I think it's been quite the yes, he had a prior charge. That's what it looks like. Again, I don't have corroborating evidence, but based off of a quick glance here, why no bond? I think it looks like he didn't have a bond agreement. He didn't come in and make one. He had an opportunity to, but just didn't for some reason. I'm not sure why not. So that'll be interesting. No money? Okay. Yeah, that could very well be. It could very well be. What was his prior? Yeah, it's when I pull it up, it looks like he had an assault on FBI agent, but that is not corroborated evidence. That is just a couple of sources here. I've not investigated it myself, so I cannot back that up. Can he ask for a bail agreement? Yes, he can. Probably is trying to do that very quickly. Trying to come to some kind of agreement. But, if he's already in jail, then, his bargaining power is significantly diminished. If there are 2 trials, would the same jury do both? No. For every trial, we would have a fresh jury. That's one of the reasons why she would want to try everybody together, is my belief, because she would want to have just one jury and all of the facts and information set out. And then that jury would go forward. But if you've got 2 separate trials or as many separate trials, there would be a separate attorney. Or, I'm sorry, a separate jury. Yeah. Does the same judge have to do all of them? It's good, I think, for continuity, and it's easier for the judges if they are in it from the beginning till the end rather than swapping it around, because then if there was another judge that came in, then they would have to come up to speed on all of the informations, all of the motions, the entire docket. So it's best for one judge to have the case from beginning to end, just because it keeps the knowledge together with that same person. But it's not required. It's definitely possible for judges to switch things up, but there would need to be a really good reason for it. Seems like the first would taint the jury pool for the second. No, not necessarily. And again, we just have to be so careful with our questions to the jury. It is absolutely possible to still bring in another impartial jury. It's possible. It would take a lot of time. I think it would take a lot longer the second time to get enough people in that could be impartial, but it would still absolutely be possible. Absolutely. Yes. Yeah, I think there's somebody on here with the mugshot already in their profile. I respect the hustle of that situation. Wouldn't all 18 be more appellate-worthy case to remand for retrial? That's a good point. That would be a very good point, actually. Yep. Before oh my goodness. That's the only one that has a chance to go through quickly. Yeah, I mean, anybody can, any of these defendants at any time can ask for speedy. I mean, unless they have specifically waived speedy, but it looks like he specifically requested speedy. So that's how that got set up. But I mean, it's not going to be to his benefit to have speedy. I mean, this prosecutor's had this information and this evidence for years, and he just got indicted, on the 14th. And so for him to put his case together is going to be a lot more difficult than for the prosecutor. Yep. Could any of those cases cop a plea agreement? Absolutely. And at any time, too. At absolutely any time, anyone here can come together and say, hey, I want, what can we do here? What agreement can we come to? But the DA really has, she's really in the higher bargaining position at this point in time. But earlier on, it's always better. If you are with this many co-defendants, the first few to come in and get those plea agreements are going to get the better deals. Do you think it'll go to federal court? I'm not sure. I don't think so at this point, just because I think her argument regarding the scope of duties as a federal employee is pretty good, especially with the Hatch Act in play as well, and with violations of the political campaigning law. So I'm not sure it'll get bumped to federal court, but I think it has to be argued. How do they fit all of these defendants and their counsel into the courtroom? Yeah, very carefully. It would be a nightmare. My guess is they'd have to move locations, but I have not seen their court, so I'm not sure what it would look like. But sometimes you just take those first couple of rows that normally we would have the people coming in, the public could sit, and so instead of that, it would be taken up with defendants and their counsel. But we'd have to kind of make sure it was carefully done. Video chat could be. It could be. I'm just not sure how things are set up there in Georgia, but it's definitely possible. I've been in cases where we've had especially in our juvenile cases where you have 4 or 5 different people involved plus all of their attorneys. So now you're looking at 10 people plus DHS plus this my people, all that I've had, and so it can get pretty full, but we can make it work. It is nuts. That's a perfect description. 4 and 5 at a time. It's possible. It's a good point. It's a good point on how they would deal with the appeals. I mean, this case is going to take a while. It's really going to take a while. And then once it's even done, of course, we've got all of the appeals that'll be coming through. So, and if you think about the ages of the people involved here, and they're going to be spending years in criminal litigation, yeah, it's a lot. It's a lot. He can't be charged with a sworn by oath to protect the Constitution of the United States. They cheated. No, even if they cheated, you can still be charged with that. Although no one's cheated. I mean, there's no evidence of cheating. If the Georgia committee boosts the DA, it still won't affect the bench's decision. How many DAs deep? Oh, that's a great point, Mama Nation. Yes. Excellent point. And you think of all the DAs that have been involved in this for this period of time. Oh, yeah. She's got some depth there for sure. Okay, Jason, sure. Whatever you say, fella. Can you explain what that means? Which part? You have to be just a bit more specific for me. Someone on NPR said that because there's so many defendants, his case may not come up real soon. I'm not sure how it will go about. I think the real litmus test will be what happens with the speedy requirement. Yeah, the governor appoints a new DA. Yeah, I'm not sure. Julie, how that's going to come into play. It's really interesting. They really have a lot of interesting rules at play in Georgia. If that's a legitimate question with the name that you have there, Mr. Username or Madam, yeah, you're going to have to double check and see how many different assistant DAs they've got and so on. Soon or not soon, we're going to see a good amount of these defendants flip. Oh, absolutely. Absolutely. I agree. They're going to be flipping left and right. They're going to be making songs about the quick of flippingness only going on. I have no doubt. I think, too, the severity of the situation is hitting people. When you go in for that mugshot and you go through that process, that's when the reality really hits. Like, what has happened? Before this, it can be all like, oh, we were just doing our duty or whatever. But when you're they're taking your picture for a mugshot, that's cold, hard truth right there of what's going on. Hold on. There may be serious riots if found guilty. Yeah, there's definitely going to be some questions. If he gets elected, are these on hold until he's done? No. The beat goes on. Man. It doesn't matter what happens in the political world. The criminal justice system has its own set of timelines and have to be followed. So, yep, the beat goes on. Yeah, innocent until proven guilty. Yeah, we still have that. Yep. Still have it. Still there. VC, I think you have a point. I mean, I think so. It said the attorney from Colorado already flipped. Really? Interesting. Yeah, of course, the flippers. He can be on trial while he's in office. Absolutely. Yep. It can be as though nothing else is going on. It does not matter that he's running or if he gets elected. None of that is relevant for criminal prosecution. None of it is important. I mean, it sounds like it because of how things are being kind of spun right now, but in reality, it's even if he gets elected, he's going to spend most of his time in court trying to take care of the cases. No, he can run if he's criminally charged. Yep, he can run. Yep, it just keeps going. Now, the question of whether or not he's fit or whether or not he should be removed, whether or not there should be an impeachment, now those are the questions to ask. The 14th Amendment. Exactly. You got it. Hello, Jay. Hello, welcome. We will see. It's up to the voters. It's up to the voters, and it's up to the people that decide the qualifications. But truly, it's up to the voters. Honestly, it really is. True, but impeachment is purely political. But at this point, if someone's on trial for a criminal situation, that could be grounds for impeachment, just in and of itself. And if you've got impeachment grounds getting through both houses for someone during a criminal trial, can Florida decide not to put him on the ballot? If that's how their rules work, whoever decides the qualifications to get your name on the ballot for people to vote for you, that's the person. Those are the people that would decide whether or not the 14th Amendment is applicable if he meets the qualifications. So it depends. It depends on your state. We act like that's just nothing. Yeah, I don't know. I think we somehow are all trying to find a way to cope with the situation. It's definitely difficult. It's difficult. I think, and for anyone, for all of us that have taken our oaths to the Constitution and then to have seen what happened, it's absolutely devastating. Secretary of State generally makes that decision. Generally so. I cannot speak for all 50 states. I just do not know the procedures for all 50 states. Conviction leads us to the 14th Amendment. Congress would have to impeach. Congress could impeach if elected, but to get onto the ballot, you have to qualify. You have to have qualifications to get onto the ballot. And if you are disqualified, you cannot be on the ballot. Yes, you got it. You got it. I'm assuming that's Betty. I'm assuming that you're Miss Betty Flintstone. But you got it. Absolutely. In general. Such a strange time to be a social studies teacher. Oh my goodness. Yes. I want to talk about all of this, but yes. Oh my gosh. Absolutely. Can he pardon himself? No. And that's specifically written into the Constitution. He cannot pardon himself. Nope. Criminal justice system gives justice to criminals, not the victims. Many people would agree with that. Many people would agree. We certainly have some problems with how our victims are taken care of. Absolutely. Yep. Oh yeah, I'm just spitting facts here. I'm not trying to spin anything. I'm just giving just the basics, going back to the basics. Here, learning how to make our sauces from scratch is how I look at it. Like, how do we make a mother sauce is how I look at it. And that's the key. Once you figure out the basics, then you can take it and run with it as far as you want to go. Absolutely. Very important. Yeah, also kind of down. I understand that too. How many defendants have the same legal team? That's a good question, and I'm not sure. I'm really not sure at this point. We had a little bit of trouble in Florida with that when we had a little bit of a question because one of the defendant's attorneys was also an attorney for one of the witnesses for the government, sorry. And so there were some questions on that with the Garcia hearing. But so far, I've not heard anything in this case. I've not heard any overlapping lawyers here. Oh, I wouldn't say that. I've been in the legal system a long time. Conflict of interest, I think that'll have to be assessed carefully. I think at every step of the way, we will have to assess conflict of interest. Absolutely. One state does deny him for the ballot. The others can still put them on it. True, but then that's the fight for the Electoral College. Yep, that's where the Electoral College comes back into it. With like all of the wonderment that comes in with that. Thank you. Oh, good. I'm so glad. I'm glad it was helpful, Julie. Yes, I'm so glad. I'm glad to hear that. Love that. I'm glad you could come by and visit. He doesn't need California to win the election. You know, when it comes down to that Electoral College, it is just those swing states all across the board. That's it. I just bought a pack of the pens you use. Oh, good. Oh, my goodness. You know, I've been thinking about putting together some links for some of the things. I think people ask me kind of the same questions for which different supplies I use. So I've been thinking about maybe trying to put together some kind of links for that so people know, or a list of what I use, but we'll have to see. Oh, hello, Captain. Good evening. Good evening. In California and New York, barred someone from a ballot. They'd almost certainly be done. California and New York, but what about Texas and Florida? You know, I mean, it really is a race to that 270 number. It gets complicated. And California does. They do have a lot, but you can kind of already predict how California and New York are already going to go. It's all of those southern states, honestly, that huge swath of the red states, honestly, that really comes into play, because when you put them all together on top of Texas, that's where you've got these questions of the swing states with Wisconsin, Philadelphia. You could make merch. Yes, I've been looking into it. I have been. It's in the works. It's in the beginning phases. Yeah, California and New York are almost always blue. You're right. And so you've got to take a look and see which states are almost always red, and then they kind of equal each other out. And then with that, now we get into the those swing states that come into play, like Wisconsin, like Pennsylvania, which has been a swing state. Michigan is another one. Arizona. I mean, it really comes down to those last ones. Have to look at electoral map to see if he could pull 270. That's what it's going to come down to. Yep, Ohio, exactly. Arizona's purple. Yeah, that's right. It is purple, isn't it? There have been a few states that have kind of go back and forth on it, and that's, I mean, hence the swing. But yeah, California's huge. I mean, they play a huge role. But yeah, Pennsylvania, Florida, Texas, exactly. You get those big states in, and it doesn't take much to get you to that 270. What's purple mean? It means that they were red and then they've switched to blue, or they were blue and then they switched to red. So Wisconsin is another good example where it's voted Democratic before for Obama, but then it swung back to Trump, then it swung back to Biden. So, it just has kind of gone back and forth. Swing states not on the ballot, he won't make it. And I think that's where the numbers start to get crunched, when you've got certain states where he's off of the ballot, plus in those swing states, those ballots, they come in and they're like, you don't qualify. That's where your numbers start to come in. It'll be a very interesting situation. As a lawyer, your opinion, do you think he can beat the charges? I really don't know, honestly. I really don't know. I look at the point that we're at with the grand jury. We've got probable cause. Do we have proof beyond a reasonable doubt? The amount of evidence that we don't have at this point, that we just don't have access to, there's just no way to tell. In my honest opinion, there's no way to know at this point because we just don't have access to all the evidence. They're almost in Wisconsin, 50-50. Okay, I got it. I'm hoping enough people move to Texas to make our blue city stronger. Well, yeah, that's interesting. I'm wondering, Texas has always been tough to call in some situations. Already claimed by the 2024 election will be so. Well, yeah, and we've already got questions going on there. Hello, Tiffany. Welcome. Which of the cases do you think is the strongest on its face? I think the strongest, easiest, maybe, is the Florida case. That's pretty open and shut. As far as legally goes, the elements that are needed for that are pretty strict. Did you have the document? Was it classified? Did you refuse to give it back? If those elements are met, then we've got guilty verdicts. That seems to be the strongest as far as, the easiest to prove. But then DC has got so much evidence involved. That's, I guess, evidentiarily, it's an interesting case, but we've also got some other questions. Was it really a fundamental right that was targeted? But we also have those strict liability issues. Like, was there a proceeding? Was it obstructed? So that's kind of a mixed bag, I guess. And then Georgia's like, I have no idea, Georgia. Whoo! Yeah, Julie, I think for sure. I think January 6th, I think it's good, but I think there are a few questions still at play with January 6th, other than because there are four separate counts, and the biggest count, the obstruction count, that's more along the lines of, was there a proceeding? Did you obstruct it? I get it. But then we've got some of these other elements where our intent might not be as strong, but I'm not saying it's not a strong case. I think it's super strong, but I think the Florida case is stronger because it's easier, if that makes sense. That one just seems like the elements are met quicker and easier. Obstruction is obstruction. Yeah. I mean, it's like, is this page classified? Did you have it? As opposed to, was your intent to, harm the situation or deprive rights? We don't really have the intent element as much in Florida. Yeah, no, it's super strong. They're all strong cases, for sure. But as far as, evidentiarily, how to prove a case, you've got, your elements are clear in Florida, I think. That wasn't the intent. It was because, well, yeah, I mean, that's a good question. Yeah, Julie, that's the $1 million question, I think, in some situations. And one that he himself is claiming could be it. Like, I didn't know, I didn't know. But that's I didn't know isn't going to work for the classified documents case, because it's just a simple matter of it was marked. It didn't matter if you knew or not. It was marked and you had it. That's more of that strict liability element to it. Yeah, I mean, again, we don't have proof beyond a reasonable doubt. I'm not saying that, but I'm just saying as far as the elements go, when it comes to just proving those elements up, mentally deranged is, well, I mean, okay. And then that person's not there anymore. My moderators. Oh, I'm so thankful for you. Look at the federal acquittal rates. They will plead it out if they doubt conviction. That's an interesting point. Again, if we look to the, gosh, I keep forgetting his name every time. I think I blocked his name because I'm so frustrated. But he was one of the Democratic candidates, and he was charged. He was indicted. Like, he had like a $250 haircut. I still can't remember his name off the top of my head for some reason. But he was indicted. What was his name? Like John. You know what I'm talking about, right? The Democratic guy that got charged. I can't remember his name. No. What was his name? Like John something. He was a lawyer. I should know. He came to my law school at one point. John something. Was it John something? Well, anyway, my story is getting bad because I can't remember the dude's name. It was a $400 haircut. But what was his name, though? Does anyone remember his name? I know. I can't remember his name either. Oh, my gosh. Oh, my story's falling apart. It was going to be a great story, too. I'll remember. I'll have to think of his name. Is it possible the other cases are stronger than it seems for non-disclosed evidence? Honestly, I think all the cases are strong. And I think it's very safe to say there's a ton of evidence being held back in all of the cases. And I think that really only solidifies it, in my opinion. Is John Edwards? Was it John Edwards? Is that a person? Is that right? John Edwards? Is that a person? No. Yes, it was John Edwards. Oh my goodness. Wow, that took so much work. Oh my goodness, that was really a lot of work. Oh wow. Okay. So John Edwards, the reason why yes, yes. Oh my gosh, that was so much work. Here's the deal with John Edwards. Okay, he was indicted, federal indictments. He had a special prosecutor come in. He was acquitted. So he was not found guilty in those particular cases that he was charged for. Now, if I remember correctly, and I may not because I can barely even remember his name, but I believe his prosecutor was the same. I believe he was the same prosecutor. So let me just put in special prosecutor. I believe it was Jack. Let me see. Yes, Jack Smith. He was the prosecutor. Anyway, the point was, we don't always win. And, it's up to the jury. Hi, Miss D. Do you think the hearings could begin? Yeah, I think they could. Absolutely. And I think the DA would be ready to do it. I mean, again, we've got so many years of work. Okay, it was him. Yeah, I mean, it happens. We gotta put it in front of a jury. It is. It's interesting. But, again, it's like you've got to prove that beyond a reasonable doubt. And this was years and years and years ago. But, these cases, I would say, are, 100 times stronger than that case, if I remember correctly. But those were campaign finance cases. Who on this list do you think will take a deal? Oh, I don't know. I wish I did. I just don't know these characters well enough, honestly. And I'll be the first to admit that. I don't know who all these people are. I just haven't paid attention. I'm only here for the law, so I really don't know their backstories. I would say the ones that have the lesser number of charges, I guess if you're just looking at it academically, would probably be more likely to flip, to kind of be, the DA would be more likely to say, I don't mind losing a couple of counts here in order to get more information in. But it really depends on what knowledge they have. Oh my goodness, t-shirts. I do. Working on it. Oh, working on it. Absolutely. Yep. Not always up to the jury. Many of Smith's convictions were overturned on appeal. Well, we'll see. I have no, I'd roll so quick. Me too. I really would. I would be the first one. I'd be like, knock, knock. Who do I talk to? What's going on? Yeah. And Jenna too. I mean, we'll see. There's no guarantees in any case. And if you're in front of a jury, again, it's 50-50. You just don't know what's going to happen. No matter how good, you do. Oh yes. Good night. Good night. Thanks for coming. Thank you so much. When do you think the trial will start? We'll see. We've got, October set down, late October for Mr. Cheesebro. So that could be our pre-test, essentially. So we'll see how that goes. But I don't know. I really feel like when it gets closer to the date, he'll waive it. That would be my guess. How do people feel about smiling in mugshots? Oh, that's a good question. Somebody was asking that the other day. I think it's tough. I don't know. It's kind of like a passport photo, right? Do they tell you not to smile? I don't know. I think that's a good question, though. You definitely want to have your makeup on. Jenna's smiling. Yeah, I mean, I don't know. Some people choose to smile. I would have to say, in my humble opinion, the absolute most gorgeous mugshot I've ever seen in my entire life was David Bowie. And I think he was arrested for just, some of the marijuana. But, oh my gosh, the picture's like, he looks like an angel, like not even human. And he didn't have a smile. So after that, I feel like no mugshot can ever compare to that one. Yeah, I mean, he was gorgeous. Absolutely stunning. Probably smile for yours. Well, yeah, fair enough. Yeah. The leaked divorce case. Oh, I don't know about that. Are you a criminal defense attorney? I have done criminal defense work. I do not currently have any defense clients at the moment. You've probably explained it, but what are the conditions to sever oneself from another defendant? Right. So you would have to prove somehow that you could, well, I don't think you can, honestly, in a RICO case because the conspiracy element is so vital. Now, I'm not an expert on Georgia law. I think the only way that this could have been severed or pulled apart would have been because of the demand for speedy. If there was somehow a timing issue, that makes sense. But because they're all part of this conspiracy, I'm not sure how they would pull it apart. Honestly. I mean, there could be questions of prejudice, of course, but again, those are going to be outweighed by the idea that they were all working together and that this conspiracy element is a key to the case. In my opinion. But I think that's, yeah, I mean, if it's too prejudicial, but yeah, again, yeah, not in a RICO. That's what I'm thinking, because we've got that element of the conspiracy piece to it. I think if it was any other kind of case, you could try to come in and break them apart, but I'm not sure here. Okay, let me see here. What do I practice mostly? Like criminal, family, etc. At this point, I have, my clients are just completely client-based based off of their issues. So there's family, I've got insurance, I've got torts. So just a little bit of everything right now, a little smattering of different bits. But I don't take criminal cases so much anymore. I've done hundreds and hundreds and hundreds of criminal cases. So I don't take a lot of criminal clients unless it's really needed. Is a judge obligated to allow individual defendants to sever from others? No. The only time it would be is if there would be a violation or an impossibility of a fair trial. And that would be a very unique situation. That would be very unique. They won't try them all together. Any convictions would be, well, I doubt it. Yeah, prejudice is the one thing. Prejudice is key here, but there are different rules that come into play when you're working with conspiracies. And that's the key to it. We have a different set of rules with our inchoate offenses. What was your most gratifying case that you've ever been on and why? Ooh, that's a good question. Whoa. Yes, I'm in the Central Time Zone. That's about all of the information that I can give out safely. So I just kind of leave it at that. Judge will decide on each defendant. True, but again, we've got the RICO piece, and that really changes the game. I'm not saying it's not possible, but I'm definitely saying it could change the game. Oh, you're welcome, Julie. Thanks for coming by. I appreciate it. Yeah, I mean, you've got so much evidence that needs to come in to show the conspiracy that you will have the other people involved in the case. I mean, they're essential elements. Cheesebro trying to see if Fanny was truly ready to go. Just wondering why he asked for speedy. I think that's a power play. And I've seen it so many times where defendants have asked for speedy and then waived it the closer that you get to trial. So it's a power play to say, hey, look, I've got some kind of power and authority here, and I'm going to just play my speedy trial card. And then they get closer and they're like, oh, no, I'm not ready to go. And then they, waive it. That's typically what I would be shocked. I would be absolutely shocked if he held on to his speedy request. That is not going to help him in this case to force speedy. It will harm him, but it's definitely a power play. Does the request accelerate them all? No, they would be individual unless any of them wanted to go forward on speedy and take their chance. It's going to expose the game to some degree. Absolutely, it will. Absolutely. Already drafting appeals. The trial hasn't begun. That makes sense. I would agree. I think they probably already have a lot of motions and things that they were preparing for. Do they have to let them postpone the trial if they request after asking for a speedy trial? That's a good question. I'm not sure what happens in Georgia. In my jurisdiction, if they waive it, everybody's just like gives them the stink eye, but then we move forward and we work on whatever case it is we need to work on. We're all kind of like, oh, thank goodness when they waive. So a judge doesn't force it into play if they waive, because it's in everyone's best interest to have a fair trial so that you don't have appeals. So if they waived it and the judge said, too bad, it's set, it's possible for them to do that, but the appeal issues would be huge. It would be, yeah. Mm-hmm. It is interesting, Brian. It's interesting that he requested, and I'm not surprised. I'm not surprised. I think that definitely happens. Why would Speedy harm him? Because, in this particular situation, we've got DAs here that have been working for years to put this case together. And he just got indicted, August 14th. And he's got knowledge of the situation. Of course he does. But he's not going to be at the same level that these DAs who've been living and breathing this case for years are at. So they're ready to go. He's the one that's not ready to go. If one is acquitted of a RICO, can that be used by others in defense? I don't think so. It could be used for maybe defense strategy, but I don't think so. I don't think that would be something that could be brought in as evidence. It would be maybe helpful for technique, but if they're all tried together, it's not going to matter because those verdicts are going to come out at the same time. Again, even if Mr. Cheesebro goes separate, if his verdict comes back in, that may give them some idea for strategy, but they would all be tried together, so they would all be decided together. It's true. If he flips, his deal would be the sweetest. Yeah, I can see that. I can see that also. Oh, you're welcome, Erica. Of course. Has anyone named Rico ever been a defendant in a RICO trial? Great question. Great question. I do not know. 19 defendants, 3 attorneys, each in one room. Cross-examination for one witness will take 3 weeks minimum. 3 weeks minimum. That judge is going to have just a tight hold on these attorneys. Oh my gosh, because you've got direct examination and then cross. I mean, and then redirect and then recross and then redirect. Oh my gosh. I mean, it's going to be a lot. It's going to be a lot. But those local rules, I don't know what they are in Georgia. I would imagine that they are like, you only get a certain number of crosses, you only get a certain number of redirects, then we're done. And they just are like, we're finished. Like they're not going to put up with a lot of it. But we will see. We'll see how it goes. The judge looks ready too. I think so. Yeah, I think so too. Illegally apply for a trademark of his mugshot. Don't know. I think that might be fair usage. I think that's in the public domain at this point. Popcorn for the trial. Oh my gosh. Oh my goodness. It's going to be very interesting. Not to mention the 19 objections. Yes. Oh my gosh. Incentive to continue to cooperate. Yes. I think we really are, we're going to start seeing a lot more information coming out pretty soon. If individuals were acting in their federal capacity, why are states involved? Okay, so great question. And the reason that the state's involved is because they're not saying they violated federal code. There's no federal law here that's been violated. Nowhere in any of these charges is federal law. This is all Georgia law that's been violated. So if they are coming into the state and violating the law of that state, then that state can file charges against them. The question here is whether or not they were acting within their official capacity as federal employees, and that's a stretch. That's a pretty big stretch. Pretty big stretch. Oh, yikes. I think the 2 female attorneys will flip. Perhaps. I think the reality is going to be really hard for a lot of people after today. I think it's going to definitely be difficult. Did they kick people out? I'm not sure what you mean by that. A stretch. Yeah, exactly. I agree. Mickey Mouse indictment. Yep. Mickey Mouse or Banana Republic, right? Kangaroo Court. Let's get them all out. What do we have? Mickey Mouse. Is it CKMICKEY? Please don't make that. Don't make that sound ever again. I'm saying to myself, kangaroo. Court. Banana Republic. Ah, just making sure I get all the getting all the terms. Did I get ham sandwich? Thank you, sir. Ham sandwich. Oh my goodness. Did we get them? Did we get them all? Okay. Yeah, I can't. Sometimes you need help spelling, you know? I mean, it's not just me, right? Oh, these are just common phrases that I hear a lot. Supreme Court. Yes. These are the key phrases that I hear quite a bit that just kind of go around and around. Yeah, I know. Oh, yeah. That was too much, wasn't it? Sometimes I forget I'm not just hanging out with my friends in here. We need to get, yes, overturn. We need to get bingo cards going so we can tick off all of the ones. Oh, First Amendment. Yes. Oh my gosh, bananas. Yes. Okay, First Amendment. I didn't realize how many key phrases we have that go around so much. So, oh, yes, we're all friends. We're all friends. Oh, the socks case. Yes, of course. The socks drawer. Sock drawer. It's an oldie but a goodie. Oh my goodness. What about Hillary? Oh my gosh. Oh my goodness. The DA's under investigation. I'm sorry, I gotta pull myself together. It's under investigation, right? Right. All right, we got them. We got them. Oh, the emails. Yes, the emails. We can't forget the emails. Oh, and the server. Let's forget the server. These are all of our key phrases that we have to have. Oh, Hunter's laptop. Yes. Oh my gosh. Here we go. Hunter's laptop. Seriously, I'm going to make bingo cards. Oh, I can't even help it at this point. It's just so much fun. The laptop. Oh my gosh. Yes. Oh, yes. I don't know. How do we make this? There we go. Let's see if we can trick the pink. Oh my gosh. You know, sometimes you just gotta chuckle. You just gotta chuckle. And that's okay. It's okay. Oh, the perfect phone call. Yes. It was perfect. It was perfection. Perfect phone call. Oh my gosh. Yes, I'm going to have to. Yes. Seriously, I'm going to make the I'm going to I'm going to have to make a bingo card. Oh, JC, I'm sorry. There are a few phrases that come out all the time in my lives. Always. And it's okay. It's just we're trying to name all of the most popular phrases that people share with us. Oh, yes, the amendment. Yes, we do. We have a lot of that. We have these are just common things that get brought up quite a bit. Oh yes, the Obama appointed judge. Appointed, yes, that's another one. Yep, I think we've definitely got quite a few of them going on after being arrested. If you're indicted and released on, what's the procedure? Sure. You know, if you're released on your own recognizance, OR, that just means that, you know, if we believe that you are going to show up, and that means, you know, you don't have to put bond down. So if you don't show up, you will get arrested still, but you're just good to go. It just means you don't have to put any money down, but it acts just like anyone else. If you don't show up, you do get arrested. But yeah, that's a lot of people will go out on OR. That's pretty typical. In fact, it's more typical than actually having a bond. All of these bond agreements are a little bit different, but I can see why, because we've got such high levels of offenses and high levels of possibility for not showing up for court. Yeah, I think most people really are. Yeah, most people are on their own recognizance. That's pretty typical. Did they indict Mickey Mouse? These are just the phrases that are repeats that we get a lot during these lives. These are just our classic phrases. I should make some merch with these on it. Can the current congressman and senators and his allies be charged with conspiracy? Absolutely could be. Absolutely could be charged. Definitely. And there's questions also with the 14th Amendment in those cases as well. Any of those cases, that 14th Amendment could come into play for sure. Yes, with interfering. Yep. I think there's a lot of that. I think there's a lot of questions about that. And so a lot more people are involved than who are just named in these different indictments. There's all kinds of different layers of this going on. We're just kind of seeing like the big ones right now at the moment. More people could get pulled in and charged. Absolutely, Kevin. You got it. I think so. I think we just are kind of seeing the beginning here. I think there will be a domino effect. Once these start to get going, it'll continue to go. The House of Cards. Yeah, I think so. I think absolutely there'll be a lot of that. Yeah, I think she is being a bit quiet, isn't she? I mean, I'm not sure what's going on with that. I think she was mad about the debate last night, I guess. Be like dominoes. Yeah. And that's what tends to happen when you have this many people kind of involved in something together, like this situation, is that more and more people will continue to follow. And we've got 30 other unnamed people in here who were involved in the situation but haven't been listed in the indictment. So I'm not sure, Suze, if they all had. At last I checked, I think almost all of them had, but there were a handful. That didn't. Oh, is my volume, is it too low? Is it too high? I better double check. It's so hot. I've got like the air blowing on all of my things. Oh, is it too loud? Do I need to turn it down? I'll have to try to figure out. Unfortunately, I feel one juror will throw the case. Maybe. Oh, you're good. Okay, good. Oh, good. I'm so glad. Oh, all right. It's fine. Good to know. Yeah, we've got rolling, we call them brownouts. I'm assuming everybody else does too, but we've got rolling brownouts here because our energy is being used so much because it's so hot. Oh, it's just you. Oh, that's okay. You just let me know if I need to change. Yes, Meadows. I mean, it's a lot. He's got a lot going on. He's really got a lot going on. Jury selection for 19. It's going to be difficult. It's going to take work, but it still can be done. State jury doesn't have to be unanimous, does it? In a criminal case, it does. And I think that's only because of a case that came down a couple of years ago out of the U.S. Supreme Court. Kavanaugh actually wrote the case, I believe. Was it Kavanaugh or was it Gorsuch? But anyway, the bottom line is criminal cases need to be unanimous, even at a state level now. But not in civil cases and not for grand juries. Right. Yeah, I agree. The jurors, we got to take care of the jurors. For sure. Let me see if I can pull that case name up that I'm talking about. So let me give you a citation here. Maybe it was Gorsuch. All right, hold on. Let me see. Oops, that's not good. There we go. Okay. Ramos. That's right. Okay. Here we go. Let me give you the citation that I was talking about. This was a pretty recent decision because we had cases before where you didn't have to have a unanimous verdict in criminal court. You just had to have whatever, your state had required. But then we had the Ramos v. Louisiana case, and everything kind of changed. It was a bit controversial, actually. The justices were pretty frustrated with each other about it. But that's the case. Let me get the citation. I hate to just give you case law without a citation here. Hold on just 1 second. Sorry. Can't remember the citation off the top of my head. Okay, here we go. Sorry, 590 US 2020. Okay, it was 2020 case. Phew, boy, that was a lot of work. Sorry about that. There you go. So we have to have a unanimous criminal jury in order to go forward with that. And that was a recent case. Would the congressional interference be defrauding the United States, depriving the U.S. justice? It could be. I could see them making an argument for that. I think. I would make that argument. Shoot, I know, right? I almost missed that case citation. We can't have that. I don't understand how a jury can preside over 19 defendants at the same time. It's mind-boggling. Yeah, it seems like it. Let me just take our fun notes away, but I'll bring them back out. I'll turn this car around if I need to with these notes, if those phrases come back out. But let me explain a little bit on what the reason why would be. If you think about it, every single defendant has been charged with this RICO charge, right? So everyone's going to have a full presentation of the RICO charge. Now, she's got 161 acts involved. She's got 3 or more people, a common enterprise. All of that evidence is going to come in for every single defendant. Now, each defendant will then have separate counts. And so these counts, you could see them being split apart. But many of these counts line up with these 161 acts. And so to be able to try it all at the same time for everybody means that all of this evidence that comes in won't have to be repeated over and over and over again to the jury. So it'll be difficult, and it'll be a lot, but it would be a lot better for a jury to hear the evidence all together rather than over and over and over again for different people. Right. Yep. Yeah. No, yeah, we got receipts. All about the receipts. I gotta have those. Don't take my word for it. No. Don't make me pull the car over. Well, you know what I mean. Is the actual number of grand jurors who voted on the indictment known or secret? It's not in the indictment, and they didn't poll the jury is the other thing. Sometimes you can poll the jury and ask them to stand up one by one, but none of that was done here. So I would guess that information is not known publicly. Do they or will they vet the jury pool? Well, I think vetting might not be the right word, only because we have multiple layers of questions. So we send out our initial set of questions, and then based off of those, we'll eliminate a whole bunch of people. Then we'll send out another set of questions, and then eliminate a whole bunch of people. And then when you come in, we'll start eliminating there. So, there's multiple sets of questions to try to make sure that we can get a really good jury pool together. So there's just a lot of different levels for it. Where do they get people for the grand jury? They are the same as anyone. If you are called for jury duty, you could be chosen for a grand jury. It depends on what's going in the court that day. So if you get pulled in, they could just say, hey, we're pulling for a grand jury. And so you might have that. Or they may say, we're looking at a criminal case. You may have that. Or, a high-level civil case. So it's anyone can be pulled in the jury pool for a grand jury or a trial jury. It just depends on what's on the docket. Yeah. Yep. How's my phone temperature? Well, let me double check. Let me check. Oh, I'm doing okay. So far, so good. Oh, thanks for asking. How will you know who may lie to get the jury, regardless of the political views? It's a great question, and I guess I try to explain it like this. Like, this is part of our job to figure out who is trying to get on the jury. And when you have done case after case after case, especially prosecutors and public defenders, hundreds and hundreds and hundreds of cases, and you've talked to tens of thousands of jurors, you get it. You get to a point where you recognize, based off of answers, what's going on with those jurors. And you build a connection during voir dire, and you get that information, and people get comfortable with you, and they start being more honest by the time you get to the further layers of your voir dire questions. And it's part of the process. But it really is training. It is absolutely something we are trained for in our field. It's just, it's one of those skill sets that we have to figure out if people are being truthful with us, if they're trying to get on the jury for the wrong reasons, and then doing our best to assess the situation. Oh, wonderful. Have a great night, Tiffany. Thanks for coming by. Absolutely. Yep. Are you allowed to show this file? This one here, this is a public grand jury indictment. So anything that I show is public, available to the public online. Nothing here is secret whatsoever. All public. Indictments for every crime or just harsh crimes. It depends on how your code lists it out. We have different levels, especially felonies. We're going to have huge indictments. When you get down to more of like misdemeanors, you're going to see more of the written indictments. You're still going to have indictments, but if it's not just a traffic ticket or a low level infraction, you're going to have an indictment. It's just typically going to be written. It's not going to be with a grand jury. You ever have jurors that are trying not to be chosen? Oh, yes, lots of times. And usually the judge will just say, nope, you're not getting out of it. Or that's the 500th time I've heard that, nope. And so we're like, oh, we really don't think that person would be great on a jury. They seem kind of upset. It's like, you still got to go forward and deal with it. All of the others have a chance to build a proper defense. Right. That's exactly right. And that's one of the things is by pushing this speedy jury, he's not giving himself a chance to really put a full defense on. I mean, maybe he has already been preparing. Maybe he knew this was coming and has something kind of in his back pocket. But, when you're forcing that jury to, or you're forcing that speedy jury to come in and into play, you're really hurting yourself in a case like this, in my opinion, because you're not having that much time to put your defense on. Really wouldn't want to be on a jury. Yeah, a lot of people feel that way. And you just have to tell the judge that when you go in there. You just have to say, look, I don't want to do this. And the judge may look at you and be like, that's too bad. You're going to do it anyway. Or the judge might say, let's talk about it. Let's work through it. Yeah, it's hard. It's hard being on a jury. It's hard. What can one do to get on a jury? I got called once, but was sent home. Just thought it would be interesting. You really can't, there's no way to intentionally really get on a jury. Like, we know if people really want to come and be a part of the jury, and we have to be careful because we don't want someone on the jury that's going to kind of lead the jury or really dominate the jury. We want everyone to really be equal and have an equal say and not really get pushed around. So, we have to be careful. We look to make sure that we don't pull anyone on that's extremely forceful, but we also want people who are like going to be paying attention. So that's really good. A lot of times people will generalize certain kinds of professions that they don't want. Like typically you'll hear a lot of times like professors are one category of people that we kind of shy away from, again, because they're seen as leaders rather than assessing the facts we give the juror. The juror may look to, the teacher that's in the group. Or if it's a medical case, they may look to someone with a medical background to rely on their expertise rather than the facts that we're giving them. So it just depends on the kind of case that you're trying. Swing to the police station, then you tell them how much you weigh and how tall you are. I don't know. It's a jurisdictional thing. The subject's too uncomfortable for you. Yes, very true. Very true. Long commitment. Oh, it would be. It would be. Like to get picked, but I would not try to get on or off. See, Suze, that's perfect. That's exactly what we're looking for. That's what we're looking for. And I was called. The court was super nice about it. Oh, that's nice. Oh, I love that. You want to be on a jury? Oh, great. That would, I mean, it's, we need it. We need our jurors. They are our backbone. They are our system. I've been on a grand jury before. It was quite educational. Oh, interesting. Was it, I'm curious as if you can speak to maybe the general crime that was involved, but you certainly don't have to by any means. But yeah, it's very interesting. Oh, he's a foreman. Oh my goodness. My goodness. It's the first case Cheeseboro's been indicted in, or was he indicted in the other cases? He's not been mentioned in any of the other cases that I have. So Florida, DC, New York. No, he's not mentioned in any of those specifically. We do have some unnamed co-conspirators, so to speak, in Florida, but is it Florida? No, I'm sorry, in DC. I'm getting them mixed up. I don't usually watch people's lives by watchers. Oh, that's so nice of you to say that. Oh, that's very nice. I appreciate that. I have a criminal justice police experience, but I never get picked for a jury. Any ideas? I think it's tough. It's tough when you have a criminal justice background because people may think that you will side with the police. And so I think it's really important to make it known, like, hey, just because I have knowledge of criminal justice doesn't mean that I've got any leanings one way or the other. I'm completely impartial. I need to have the facts before I make a decision. And, those kinds of things are really key to just emphasize that there is no favoritism, I think. That's one thing that can kind of help. Oh, thanks for coming. Thanks. I appreciate it, Professor Foxy. It's good to see you. Anytime you can come by, I'm thankful for that. Absolutely. Federal grand jury for 1.5 years. He hated it. Oh my gosh, that's a long time. Oh, that's a long time to be on a jury. If you want to be on a jury, there are e-jurors. Oh, that's interesting. I didn't know that. Only jury I was on was a civil case. Okay. Very interesting. Civil cases are relatively rare, actually. That go to trial. I mean, criminal cases go all the time, but civil cases, not so much. You can't serve in Texas. Oh, really? Okay. Well, I can see that, though. I can see that. More like break the law, get indicted. Yeah, yeah. Landed status in the U.S., received at least 10 jury cards. Just right Canadian. Oh, my goodness, that's a lot. That's a lot. That's a lot of times. That's more than your civic duty there when you've been called. When people confuse your cases, there's your sign. Well, it's a lot. There's a lot of cases. I won't show you my paperwork stacks here. It's a lot. It was a pretty tough one. Yeah, fair enough. Oh, thank you. Thank you so much. I appreciate that. Can a jury rule guilty on some and not guilty on others? It's possible. It's possible, even with a RICO case, because you need 3 or more. So it's possible to just be at 3 and the rest not be if there are elements missing. It could happen. Everybody has their own specific set of situations and statements and dates and times. And so each one of those will have to be proven beyond reasonable doubt to the jury. So if one person's statements were not seen as proven beyond a reasonable doubt, then that person would not be convicted, but then the others could. So it really would depend on who was, the facts and the information that's given to the jury. So on a jury for insurance fraud, insurance company lost. Oh, interesting. I mean, I hope it was interesting. I hope they made it interesting for you. I think insurance cases can be a bit dry, but they can also be interesting as well. So depending on the attorneys. I'd like to be on a jury, but never been called. Well, someday. This will probably be it now. This will be the sign. It's going to happen now. Former 911. Is that why I've never received a jury summons? It could be, although it really could just be luck of the draw. I mean, it has to do with it's pretty random. I wouldn't say you'd be shelved or put on a list where you wouldn't be called. You would need 3 guilty for the conspiracy elements, or can 1 get guilty? I'm not exactly sure how the RICO statute in Georgia works, but with conspiracy cases, in general, you need to have 2 or more people. In this case, it's 3 or more for RICO, but 2 or more in conspiracy. So 2 people have to be found to have gone together. If you don't have those initial people, you don't have a conspiracy. So you have to have that minimum number met. That's the minimum requirement for a conspiracy, or else you don't have it. So any of the conspiracy charges could get tossed, and if you can't find 3 or more, then the RICO could get tossed. Is what I'm trying to say when we do our inchoate offenses. Right. What really happens if you get summoned and you don't go? Nothing good. Nothing good happens. It depends on how big your jurisdiction is. If you think you might be able to hide by falling through the cracks, you could try that. But, it's like, we really need people to show up, like we really need it. 2 or more people, but 3 or more charges to convict. No, I'm sorry. I was giving an example of just a regular conspiracy. So the conspiracy element involved in a RICO is 3 or more people. That makes up an enterprise. The idea of conspiracy in general is 2 or more people. Okay, so under count 1, we need 3 or more people. Under count 9, which involves a conspiracy, you need 2 or more people. There's 2 different types of conspiracies involved here. Sorry about that. Yep. It gets confusing. The cracks have worked out good. All right. Well, there you go then. That's all right. You got to do what you think is best. I don't know about your jurisdiction. Mine's in a situation where it's possible your name would get pulled back up again pretty quick. So, Oh, hello, the captain. How are you doing? Welcome, welcome. We are trying to work out the ins and outs of this indictment. As soon as you register to vote, you're in the jury pool. Okay. Very good. Yeah, that makes sense. Haven't dealt with conspiracy or RICO. Yeah, and, RICO, again, is just this idea that there's this corporation, but it's not like like an LLC or like an incorporated corporation. It's this idea of this group. And by group, they're requiring 3 or more people. With a conspiracy, it just means you have 2 or more people. So more than, you don't need 3 to make an organization. You just need 2 or more people for conspiracy. Yes. How was your life? Was it good? No, welcome. Anytime. We're just having a good chat. I didn't register to vote till I was 20. Got my first jury summons when you're 18. It could be a vehicle registration too. Sometimes a vehicle registration will do it. Anything where you have to sign, your information with the county, with the jurisdiction you're in, can do it. Racketeering off the grid. Yeah, I think that's a good way to put it. You're going to go over the documents, just answer questions. I've already been through the documents for tonight. I will have something posted up on YouTube later, or the tube of you. So this is kind of the Q&A after the documents reading portion. Was your driver's license? Sure. Oh, yeah, sure. Do we know what role each of these people allegedly played? Well, what they have done is they've set out the counts right under their name. So if you match the counts up with the different charges, then you can kind of see who said what and when they said it. They know you're a green card. Well, it could be because of taxes. It's possible. I think, I think it could be taxes. Yep. Taxes. Racketeering, influence, corrupt organization. Yes. That is the RICO. I didn't feel it's appropriate. No, it's fine. I try to not get up into personal business either. No problemo. Although I do talk about documents. Anything that's public record, I'm all up in that business. That business can't hide from me. Yep. Absolutely. This is my business. Yes, there was a lot of that going on. I think so. I hope anyone that does get jury duty, though, does come in and, you know, help as best as they can. Yeah, this is all public record. Yeah, no, I wouldn't put any private information out there. Nope, absolutely not. That's not my role. Roles were reversed. We wouldn't want the same done to us. Oh, you mean regarding indictments? Fair enough, but it's public record and it's an excellent learning opportunity. And we're all about the education. So let's, learning is important. I think that's very important. And this case is an excellent case to learn from because there's so many defendants, so many charges, lots of information. Yes, I certainly can. Couldn't do these juries because I'm too biased. Well, the fact that you know that, I think, is really good. I think if you realize that when you're going in and they're asking the questions and you say, look, this just isn't going to work, and you make that known, I think that's fantastic. I think that's excellent. Yeah, absolutely. Yeah, I mean, I get it. I mean, it's tough, but it's also, it's public record, and we learn, and we have to figure out what's going on. And, I like to help people figure out what's going on. Nothing normal about this case. Well, I mean, it's normal in that we have defendants that have violated the law. That's pretty normal. Are you a teacher? I am, yes. I am currently taking the next 2 semesters off, but yep, I've taught for a very long time. Criminal law, evidence, criminal procedure, constitutional law, torts and litigation. I've taught a lot, and I really enjoy it. They still choose you anyways if you admit to being biased. Typically, no. If we've got someone that's sitting on the jury, honestly, what happens, I'll tell you what really happens. I'll give you the inside scoop here. When we make our jury list, and I don't have my chart in front of me here, but when we set out our jury list and we've got someone that we know is so not good for the jury, and they are biased and we're going to have issues, then we will try to get them struck for cause, which means we ask the judge to remove them. And the judge is like, I think they're okay. What typically happens is each side gets a certain number of peremptory strikes, meaning we can eliminate a certain number of jurors. And what will usually happen is we'll look at opposing counsel and we'll try to figure out which one of us is going to be the one to use one of our strikes to remove that person from the box. And so eventually they will get removed. It's just a matter of who uses their strike in order to do it. What's the difference between a paralegal, an attorney, and a lawyer? If there is a difference. Oh, sure. A paralegal is kind of like, a paramedic. They are trained in the law. They can do a lot of things, incredibly important, essential people in our field, but cannot give legal advice, cannot practice law. So they are at that kind of next level down from an attorney only because they can't go into court and represent. Attorneys and lawyers, those words get used interchangeably depending on where you're at in the country. Sometimes it means you're licensed. Sometimes it means you're not licensed. Sometimes it means you're more academically inclined versus more trial court inclined. It really just depends on kind of the local language, but they are pretty much used interchangeably, although most often attorneys are those referred to that are licensed. I'll do the paperwork and research and the briefings. Yes, absolutely. Yes, and I think the voir dire process of the O.J. Simpson trial is very interesting. It's very, and it's something that is used in some of our trainings too. We get a lot of training on voir dire. We just have to. Looking into degree program in law. Why is criminal law separated from regular law? We have a separate code because honestly, it's because of how it's set out in the Constitution. We have criminal law and we have civil law set out in the Constitution, different rights, different amendments that cover those areas. So criminal law is really where all of the trials take place, honestly. Although we do have a lot of civil litigation, but not nearly as many trials in civil court as we do in criminal court. Yep. Yep. Exactly. What does a paralegal do? Pretty much, you know, going in, talking with clients, taking them through the paperwork, all of our discovery process, putting all of those things together, preparing our documents. Sometimes we ask a lot of legal research, like, hey, this is my issue in this case. You know, what's up with case law going on in there. A lot of times it can also be organizing our trial binders. That was a huge thing, is putting our trial files together. Some of us still use paper files, some of us use electronic files, but either way, getting our trial information all together, putting our demonstrative exhibits together, so there can be a lot of that is involved as well. So it's really just complete support staff, making sure the attorneys don't miss deadlines. Of course, that's probably the number one. And that we get back to the clients that keep calling. Yes. Yes. It truly, I mean, they are our paramedics. They really are. They really are those first contacts and kind of that triage with our clients to kind of set things up for us. Yes, the grunt work, the key, essential, necessary work. So criminal, you're going after people, and the other's business problems. I would say that's accurate. Probably the best way to look at it is in criminal court, the biggest loss that you can have is honestly is the loss of life, the loss of freedom. But in civil court, the worst thing that'll happen is the loss of property or the loss of money. So if you look to see what the biggest harm is, the worst amount of harm will be in criminal court as opposed to civil court, where again, you're looking at an injunction or you're looking at some kind of loss of property. That's truly the biggest difference, the best way to differentiate between those two worlds. The behind the scenes of all the things. Yes, that's so true. That's very, very true. Very true. Work under an attorney. They can't practice independently. Yes, exactly. Yep. Yep. What do you feel is the best to pick for job security? Oh, there's job security all over the place. There's always people needing help when you're going into the field. So it really depends on what area you're comfortable working in. And if you want to switch around a few years down the road, that's up to you. But, it's really going to be up to you what area of the law works with how your mind works. Let's see. Are there indictments pending, do you think? That haven't been filed yet? Yes, I think there are charges out there, indictments that have not been filed yet. I think we're kind of in a slow burn kind of situation, but I think it's going to start coming quicker, in my opinion. I wouldn't be surprised, I guess. Can a hospital be liable for not informing parents of a newborn's congenital heart condition? Ooh, that's a very specific question. Interesting. I'm not sure. I'm not sure what the mandatory requirements are for telling parents about the condition of infants. It would definitely be a jurisdictional issue, but I really don't know. I'm not sure. I think each place has different standards, even so much as even the hospitals would have different standards, even in the same town on that, in my opinion. I heard there was not enough attorneys to go around, especially with public defendants. No, that's just not true anymore. I mean, they have too many cases, of course, but it's not because we don't have enough attorneys, it's because we just don't have enough money. And so people don't hire enough public defenders. We don't have enough paid for by the state. The budget's too small. So there's plenty of attorneys. It's just a matter of actually paying them. That's the issue. Yep. Frivolous lawsuits. Yes, we do have some frivolous lawsuits, but we have a lot of checks in place to try to keep those off of the table. There's multiple phases that you go through in order to bring your suit, and you have to kind of pass go at each stop in order to keep your lawsuit going. So we do have some things in place to help with that, but it can be. I think one of the biggest problems is that people have an idea when they think of a lawsuit that, if someone bothers you or did something that you don't like, you can just sue for $2 million and, that's it. And it doesn't work that way. You have to actually have damage, and then the amount of damage has to be assessed, and then that's all you get. You just get the amount of damage that you've suffered. And sometimes it can be punitive damages, meaning, the party needs to be punished, but those are very rare. Healthcare, there are so many variables. Very true. Yeah, there really are. It's a tough question to ask. Do you enjoy going into court and presenting the case? Sounds super scary to me. It's been a while, honestly, since I've put a full case on, and I'm not mad about it. I feel I've done hundreds and hundreds of cases, and it takes a lot out of you. I'm glad of the work that I've done, and I'm glad I learned so I could share it with other people. But it wears on you. It is hard, and your relationships suffer for it. The people around you. If you're getting ready for trial, you just turn into a bear, and you're just almost not able to communicate. You can't eat, you can't sleep, you can't function. It's extremely stressful. While you're in it, you do it because it's your job, and I enjoyed it. But when you look back at it, you're like, wow, I somehow made it through that, and I'm not sure. I think it's a bit like people who do really, who train and do sports professionally. Like if you're at the event, it's really hard and the training's difficult, but then you look back and you're like, whoa, I don't know if I can do that again. So I think there's an element to that. But, in our profession, the tools are your brain. I mean, those are the tools of our trade. It's your brain and your ability to argue. And it can take a toll on you after a while. There's a lot of elements involved. But I loved it. And glad I went down that road. If I need to go into court again, I will. But that's not really on the horizon for me at the moment. Hopefully that answered it a little bit. I enjoyed. I absolutely enjoyed it. Getting into, yes, litigation findings. Ooh, interesting. Punitive is very rare. Yes, very, very rare. Isn't that why punitives are so outrageous, to stop the act from continuing? Exactly. That's exactly the reason. Catastrophic injuries, med malpractice, product liability. Yeah. Oh, that's so sweet of you to say that. Okay, let me see if I can say your name. Aroli Xavier. Oh, what a great name. Love that. Yes, well, I try to come out and just give some information to help people out, help understand the process. Good night. Thanks for coming, Kevin. Appreciate it. Just entering the field, bar results in October. Oh, well, that's exciting. And the thing is, I've been in it for a real, real long time too. So that's the other thing. You get to a point where you're ready to start sharing with other people as opposed to actually diving into the deep end yourself. Well, good evening, Ava. Good evening. Absolutely. Good luck. Yes, for sure. Absolutely. Yeah, it's, if it's for you, it's for you, and it. Once you get in, you'll know if it's a good fit or not, and you'll stay in it or you'll move on. Thank you for your time. Much appreciated. Most attorneys don't want to talk about it. Oh, yeah. Well, you're welcome. You're welcome. Absolutely. And I do have my messages on right now. I'm still doing okay. So if you want to message me through TikTok, if you've got specific questions, I am taking messages right now. So I'm not sure how much longer I will be, maybe another week or so. But yeah, feel free to ask me any questions if you have any. I can give you some specific answers. In New Jersey, do you think any of these will stick? It's likely, statistically, if you look at the sheer number, I think something's going to stick. I'm not sure what exactly, but what would you do if you weren't an attorney and a teacher? Oh, that's a tough question. Oh, that's a really tough question. Wow, what would I have done? Whoa. Wow, that's really thrown me. to think about that. Yikes. I don't know. Maybe I might have gone to cooking school. Maybe I love to cook, so I think that might have been an area that I pursued. I absolutely love to cook, but that would be about it. Oh, thank you so much. Thank you so much. Wasn't me? Yes, welcome, welcome. Of course, of course. My attorney friends don't talk about this case at all. Well, it can be tough. I think it's an exceptional case to learn, though. I think it's really good. One of the co-defendants will flip. I think at least one. I think we're going to see some people flipping pretty good over the next few weeks. I think we're going to start seeing a lot more information. A lot more details are going to get hashed out. And I think a lot of people are going to start to really assess their situation. I think we've got reality checks when you go in for that mugshot. And so I think some people are going to be thinking about that. Culinary arts or public safety. Oh, yeah, I wouldn't mind. I wouldn't mind doing cooking. That was definitely a happy place for me. If they flip, will charges be dropped? It's possible. Absolutely possible for immunity or reduced charges, or we would call it like more of a lateral move. So instead of having this charge at this level, it could be moved not necessarily down to a lesser charge, but to a different charge that would have a less negative effect in their criminal history. Absolutely could be possible. I think some have already yes, I think so too. I think there's definitely everyone's in talks for sure. Absolutely. Yeah, when it comes to Stuart, when it comes to super specific questions, I'm just not able to get far enough into the details of anybody's particular case. I just have to be really careful about that. I just do general legal education as opposed to specific cases. I can answer general questions, but very, very specific cases, just kind of outside of my ethics when I'm on the TikTok. So sorry about that. Could it be dropped to a misdemeanor if they flip? Absolutely. Absolutely could be. It's up to the discretion of the DA as long as the judge agrees with it. That's the thing about plea agreements. If you take it in front of the judge and both sides agree, but the judge is like, no, I don't think so, then it won't go forward. But it's possible. Absolutely. Absolutely. Emergency management. Oh, yeah. I think this is really going to be a fascinating situation to watch unfold for everybody involved, without a doubt. These level of charges, oh my goodness, yeah. There will be some people who are trying to assess their life choices and based off of that coming in and trying to figure out what's going to work out best for them. Absolutely. Still be on their criminal record as a misdemeanor. Yes. Absolutely. But that misdemeanor is going to look a lot better than felony convictions. Like, look for Mr. Giuliani here. We've got all of these counts are all felony counts. Now, of course, he's very well known. But for him to have this many felonies, I mean, if he serves the time, even if he gets minimum time, he's still going to be a convicted felon with all of these levels of felonies on his record. When do the police start letting you tell them how tall you are and what you weigh? It depends on your jurisdiction. It really just depends. And in fact, in my area, our city cops wouldn't ask that, but our county deputies would. So even based off of where you're arrested can change, even if it's the same town. It really is dependent. How did D11 violate charge 8? I'm not sure. Rudolph Filoni. Oh, come on now. Come on. All right. I got to turn the car around, everybody. This car's getting turned around. The dad jokes are coming in. Here we go. Got to put them out again, reminding everyone. Here's our key phrases, and now we've got the dad jokes. Oh, goodness. A misdemeanor would make it really difficult to get another job in the future. Yeah, but not as hard as the felony. Right. Defendant 11, violate the 8th charge. Yeah. Right. So we had Mr. Schaefer. He's number 11, right? And he impersonated a public officer, which was the elector. He came in saying he was the actual elector when he was, in fact, a fake elector. So that's the impersonating a public officer charge. Like dad jokes. So there's that. Hey, nothing wrong with a good dad joke, as long as it's a good dad joke. Oh my goodness. Hopefully that answered that question, if I was reading that correctly. Giuliani used to pursue folks. He did. He was all about that RICO world. He was all about that. Is that the mood ring? Yes, I do have. This is a different mood ring than the one I usually wear. This one changes color faster, so I thought it might be fun to see the colors change pretty quick. I did. I had to pull the car back around. I had to pull it over. I think we're back on track again, though. Jersey would be totally different outcome. I really need help. Okay. Interesting. He's flipping because why would he not? Yeah, that's a good question. Impersonating a serious concern. Yes. Right. Oh, thank you. Oh, that's so nice of you to say. You're welcome. Hopefully, you've been able to gain some knowledge and some information to take with you. Oh, thank you. Yeah, I think the color is really pretty. It turns out really pretty on camera, I think. So, turned out, yeah, it's kind of fun. It's a little fun. You got to have, fun when you're dealing with really incredibly difficult issues. Sometimes you just got to laugh a little, for sure. Yes, it is. Yeah, you can message me. I've got my messages open right now. Well, thank you. Yes, I've got to, I've had some people ask me about my different rings, and so I need to go back and remember where and how I got them. I don't remember. In a RICO case, it really is. With his history and his claims of how much he cleaned up the streets, I mean, I think it's interesting. Very interesting. Kids asleep, wine poured. Love to hear that. Love it. Love to hear it. Oh, it is. Yes, it is. But yeah, no, it's a mood ring, and I just love it. I love the colors. Pretty vibrant. So I'll try to keep it going. You started 3 rings. Oh, that's funny. Yes. I need to, I'm trying to keep it interesting with my rings here, but I only have a certain number. So I've got limited ring capacity here. I'm doing my best for you, though, for everybody. Impersonating's a huge charge. It is. It really is. And again, that's the impersonation of a proper elector. And that's by the people that came in saying that they were a proper elector, and they knew that they were not. You're looking for rings. Oh, good. Love that. It is. It's a bit of a blast from the past, isn't it? Sometimes the oldies are the goodies. I enjoy those. Sometimes it's good to have fun. $1 for me. We can see. Okay, yeah. You just give me a message. Send me a message. My messages are open. I can help you with that. I can look at it and make an assessment as to whether or not I can assist or not, but we will see. I'm not taking clients. I just provide legal education. That's the best I can do. What do you think about Tucker's interview? Do you think it'll hurt? I have not seen the whole interview. I've seen bits and pieces, and honestly, it's a bit concerning. Some of the language is a little bit concerning. I'm still processing, honestly. That's my true, honest answer. I'm still processing what's going on there. Kids asleep, wine pour, rings, status, charges chronicle. Yes, love it. Love to hear it. Do I have any rubies? I do. I do have a ruby. I think I was wearing my ruby earlier today. Yes, I do. I do. I'll have to wear that one at some point. It seemed like I wasn't quite sure based off of his language exactly what went on there, but there were a few things that were said where I'm like, what? I'm not sure. So Yeah, I think so. Tucker seemed to kind of open those doors. We stayed on with the captain last night and watched the interview. It was concerning. Really? Yeah, no, I had to go last night, but yeah, it seemed, just from what I've heard, just the snips have been like, I'm not sure about that. Will Meadows get his case moved to federal court? I doubt it. I think it's a good try, but I don't, at this point, I don't think he's got a strong enough argument to get it to federal court. Facts lead to the truth, but truth is more about meaning. Well, I think there's, for me, I just see, defendants and charges, and then, we'll see what, we've only got probable cause here. Finding beyond a reasonable doubt, that's up to the trial jury. So that's kind of where I'm at with that. Thinks his words last night could be interpreted as evidence. I think so, yeah. I think anytime he says anything publicly, it can be used as evidence. Absolutely. And they're probably making that assessment right now. Red sapphires, really interesting. I had a green sapphire once. I wonder where that went. I should look for that. Those are pretty, very pretty. Great day in America. No one's above the law. Yeah, that's exactly right. We got to follow the rules. Everybody's got to follow the rules. Yelling at your screen during the debates. Yes. Cause probable. Probable. Oh my goodness. I tell you, just come on. You give me these crazy words. Oh, I love it. The mugshot's scary. Yes. Yeah, somebody was on earlier and just had changed their picture to the mugshot, which I thought was like quick change. Meadows wants a pardon. Yeah, and that's just not going to happen. And the mechanisms aren't in place for a pardon in this kind of a case like this. I mean, I think the state legislature would have to approve it anyway. And even if he gets to a federal level, no, it's a mess. That's not really on the table for him. Mugshot it. You may need to put your wine away, sir. Going down in history books says, yeah, it really is horrible. It is horrible. Rubies and sapphires, second hardest gem. Well, that's interesting. I did not know that. Very interesting. Yes, it sounds right. In your opinion, how many folks were involved? Because I'm thinking more than we thought. Oh, yes, absolutely. Many, many more. I would not be surprised. I mean, if you think about the hundreds of witnesses that were in front of Congress, absolutely. I mean, there were a lot of people involved here. A lot of people. Why wasn't that interview a violation of a sentence with the no contact with the media? It might have been. They may still be assessing the situation. I mean, we move slow in the legal field. And if there's a legal violation, it doesn't mean that it's not going to go forward. It just means everything's being assessed. So it's very possible that it could come back as a charge. How many hours did he practice that? Well, that's a good question. I know I would. Cheese broed. Oh my goodness. We should all receive a law degree after this. Oh, thank you so much. Yes, all honorary degrees across the board. Absolutely. Everyone's working so hard to get the lingo down. You got it. Absolutely. I agree. Yeah, Nixon v. Fitzgerald's not good law. So I'll just leave that there for you. It's just not good law. Just look it up. Just look up the case, and then you'll see which cases actually came after that. And in particular, Clinton v. Jones. So that's the case that overruled the Fitzgerald case. I think it was recorded beforehand. Oh, yeah. That would make sense. Oh, that's an interesting question, isn't it? So if he recorded it before he was given the conditions, but then it was uploaded after the conditions and he knew what he said, or maybe he forgot what he said, was it a violation? Wow, that would be an amazing legal question. Oh, you're welcome. Dinah. Thank you so much for coming. How does a bond take place? It just means that you put a certain amount of money down saying you're going to come to court. And if you don't come to court, then the court takes that money and then puts you in jail. That's how the bond works. Yeah, isn't that an interesting question? Dork squad degree. That's not what to do with the degree. It's the friends we've made. Oh, it's so true. Oh, I absolutely agree. Him threatening. It was wrong. It was really, I mean, it was awkward. It was awkwardly wrong. It is a great question. I don't know what would happen. I think it's an excellent question. Do you get the money back? Absolutely. Yeah, if you show up and then at the end of your trial, when everything's all done, yep, you get your bond back. Yep. It's just to make sure that you come to court, that you come to your court dates and so on. He'll flee. Well, I mean, it's possible. He's got the resources. It's not out of the realm of possibilities. For those asking for a speedy trial with a difference, have enough time to go through discovery. The defense, no. I mean, the state will just probably information completely dump all of the information, but the defendant will literally probably not have enough time to read it all, which is another reason why it's tough in these kinds of cases to pull in that speedy jury request, because it can potentially harm the defendant because he needs to be able to go through all of the evidence. So it's definitely not helpful for him to pull in that speedy trial situation. It's his right, of course. Of course, he's got that right, but it makes it more difficult. Yeah, and I think a lot of it is really this issue that we don't have people saying like, oh my gosh, I was set up, or I didn't do it, I've been framed. We don't have any of that, which is what we usually have in court. What we have are people saying, I did it, but it's okay. And I'm allowed to do it, and that's fine. I mean, we have so many admissions, it's like a dream world with all the admissions, but they're saying, but I have right to be able to do it, which is completely bonkers in criminal cases. It's just completely flipped the narrative. Horrible for... I agree with you, Boxer Mom. I agree. It was pretty awful. Possibilities. Well, listen. There's too many apostrophes. Realmed. Okay. Possibilities realmed. Got it. The realmed of possibilities. That's hilarious. Yes, the mugshot's been going around a little bit. It's been going around. We've been seeing little snippets of it. It's, I mean, it's part of the process. We'll be talking about co-defendant cases. Absolutely. Yep. And we spent the first couple hours on the live tonight going through Mr. Meadows' situation. So tonight I was focused just on the DA's response to Meadows' request for removal to federal court. She just filed her response yesterday, and then we went through a lot of those different kinds of issues. But I also do come on when new things come down for the Florida case as well as the DC case. I don't focus on New York, but I do focus on the other indictments too. So, yep, the mugshot. It's been done. Do any of these attorneys still have their law license? I think so, although I think some have definitely had them removed. I know for sure Giuliani's has been taken. I think Eastman is in the process or just had it removed. That's the only ones I know off the top of my head, but I believe others are in the process or have already had them removed. So, yeah, I mean, it's definitely in the works. It's in the works. Is it true that most charged with RICO are more likely to be convicted? I don't know. I'm not really sure. The RICO cases coming out of Georgia and the way that she's done them in the past are pretty hardcore. And the people that she has gone for and have been indicted have been held accountable. Again, I don't know exactly how the RICO cases stack up against the federal RICO cases as far as Georgia versus federal goes, but it seems like that's pretty much her record. Just had a crazy case happen in California. The young girl that was, oh, that's sad. I hate to hear that. That's unfortunate. We don't like that. Man Easted. Yes, Man Easted. this fella. He's got a very interesting case out of California. If you ever take a look at some of those documents, oh my goodness, that's where all of the memos that were in the DC case, those all got, well, not leaked, but those all got shared to the public because of filings he had in his case in California. It's fascinating. It's very interesting. Oh, hello, Stressful Sam. Hello, welcome. Yes, it's an ego thing, to some degree, for sure. Yeah, no, those documents, I mean, it's something else. Those are documents that I just was not comfortable reading actually online. So I've not gone through those, but they're interesting. He's got, look him up. He's got a case in California. Yeah, BRB. It's interesting. It's some interesting documents that have been filed there. If you are ever wanting to dig a little bit deeper into his situation, he's definitely got some interesting turns there. What's the best way to find certain cases? It depends on which kind of cases you're looking for. If you've got specific citations, of course, you can, Justia is the best place. But if you're looking to do research, like academic research, Google Scholar's good. If you're looking for just U.S. Supreme Court cases, Oye is good. If you're looking for different states' cases, then I would recommend Cornell Law Institute. Eastman case, California, federal. I believe so. Yeah. Let me pull it up. I can give you the case number. I believe it's called Eastman versus the January 6th committee. I believe is the name of that case. Let me just see if I can pull that citation up. Okay, yeah, let me give you the court number here for those who are interested. Okay. Yeah, so that's the name, or that's the number, and it's Eastman versus a whole bunch of people, but we've got Thompson at the first, who was the chair of the House Select Committee investigating January 6th. There's some interesting documents going on in that case if you are wanting to go down that road. Yeah, I think Pacer, you can just pull it up. There's several different sites that have PDF versions of all of the different documents. Yep. Yeah. Take a look. I mean, it's an interesting rabbit hole to jump down if you're fascinated. I don't like that yes. Oh, that's sad, isn't it? I agree. I'm with you on that one, Snappy. Yeah, no, it's interesting. It's great, educational. Just the information included in it was not something I really wanted to share online, so I just had, I think it's better pursued individually for those that are interested in it. Yeah, well, he didn't want to testify, and he had some other issues going on, so it's an interesting case. It's got some interesting twists and turns to it. There was a complaint for declaratory and injunctive relief, but there's multiple filings in there, and the exhibits are really what get fascinating. Again, that's where those memos come out through this lawsuit that was filed. So, yep, it's fun, interesting. Maybe fun's not the right word. Maybe if you're a legal dork, it's fun. So maybe that's okay. But how many co-defendants on the Eastman case or on the Georgia case? In Georgia, we've got 19. And then in this one, he's actually the petitioner, and he's suing the committee. So there's like 4 or 5 different ones. yeah, that are involved. One of the reasons my lawyer friends aren't really getting into this case is because they deal with sovereign citizens. Oh my goodness. Yeah, that's a lot. Do you know who is? I don't. I have no idea who's underwriting his legal. One word synopsis of Eastman versus Thompson. One word. Entitlement, maybe? Or ego, perhaps. Could be some interesting words. Think about the fact that the leader of the Republican Party is running a campaign. Oh, I know. It's been, yep. I know. What can I say? My vocab is limited. It's becoming limited after all the dad jokes. Oh, yeah, megalomaniac. That's a good one. I think that's a pretty good one. I'm trying to not be too, I'll read you the first sentence. The November 3rd, 2021 presidential election was one of the most controversial in American history. There you go. January 6th, approximately 500,000 people gathered for a Save America rally outside the White House. So that's second sentence. That gives you some idea. It gives you some idea of the madness that is this case. It is just madness, complete madness. Wouldn't Eastman's emails be subject of the university account? It could be, but his emails are so well known now. I think they're just all over the place. I mean, they're everywhere. Case ending in federal courts? No, I don't think it'll go to federal court. In my humble opinion, I don't think there's enough to stand. I don't think they've got a strong enough situation to take it to federal court. How close 45? Oh, yes. Yeah, there's a lot of sovereign, and sovereign citizens cause a lot of trauma in the legal field. I mean, it's, almost assaultive how they use paperwork as a way of trying to just overwhelm attorneys. It can be very detrimental. Absolutely. It's very difficult to deal with it. It's one thing to be like, oh, that person's being ridiculous. And it's another thing to get bombarded with 100 pieces of documents that you actually have to respond to in order to get them all dismissed. I mean, it's exhausting. Why is it when the defendant asks the people's court to not speak in legalese, they look so confused? I don't know. I'm confused. I'm not sure. The expectation of privacy doesn't apply to electronic devices of your employer. Excellent point, especially if it's a government employer. It's not going to federal court, quite literally. For what? Yeah, I think that's a good question. It's not really a solid case. I think it's a valid case, but I don't think it's solid. Mary, who did tell all from the childhood, testify. It's possible. In fact, I think there's some litigation going on with her still. Is that true? I get all the cases mixed up, but I thought she had ongoing litigation. I wasn't sure if it was for defamation or not, but that could be just, I'm getting mixed up with defamation because so many people were getting sued. He sued CNN. He sued his former attorney. Lots of people have been getting sued. Still here. Hi again. Yes, we're still here. Oh my goodness. Yes. Darrell Brooks defended himself using, yes, it was nuts. I remember watching that and thinking to myself, this is completely nuts. I don't even know how this is happening. There may have been some yelling involved. There may have been. It was very difficult. You never sleep. Well, I need to at some point, but I'll get there eventually. Yeah, we had heard some rumblings about that. We weren't sure exactly what happened. Could testify to what she knows is true, but conjecture and hearsay would be exempt. True. And I think, we have to be careful when we're talking about, if they really wanted medical information, they would want to pull somebody else in, but she could be good for reputation or character which are very, very narrow allowances, of course, but it's possible, but she probably wouldn't be the best one to choose. I think she'd get probably destroyed on cross-examination, in my humble opinion. And, she just doesn't need to go through that. There's other ways to prove what they're saying without having her get, set up that way again. She's been through a lot, in my opinion. Certain levels of privacy do apply to employer-owner devices. Evaluations are protected. But the employer sets those out. The employer will set out which things are private and which things are not private when it comes to a private company. But you're right, there can be some restrictions put on that. Come in for sentencing. Yeah, that would be a good point. She could be relevant for that, for sure. Yeah, character reference. Yeah, I think so. That could work. That could work. I'm still thinking about the employer-owned devices. When you're dealing with a university, too, there would be some special rules that would be applicable there. By the Right to Privacy Act. Yeah, there's definitely some pieces that would apply there. I'm not sure exactly what those rules would say, but, okay. Excellent. Bring it on, Snappy Squid. Bring it on. Let's have it. What do we know about the Right to Privacy Act? Or were you talking about Mary testifying about a diagnosis? Emails are not university property. Okay. Good to know. Thank you for clarifying that. Excellent. Phone can be wiped by your employer and they don't own it. That's interesting. Ooh. At least at UC. Okay. That's good. That's good to know. Very good. How many states left to file against him? Oh, we've got a few still. I think maybe 4, 5. My phone's about to say I'm done. Lovely chat. Yes, thank you for coming, Ava. It was great to see you. Thanks for stopping by. Appreciate it, as always. Have a fabulous night, of course. Having a field day with a mugshot. Yes, oh my gosh. I'm just, This is our reality at the moment. I'm taking a minute to take it all in. It's not easy. Oh, yikes. It's been a big day. I think, for everybody. And, good and bad for sure. Such a good job explaining. Oh, thanks, Chris. I appreciate that. I do try my best. I do try. I do. Sometimes I miss, but sometimes I hit too, so that's okay. Oh, I do try to do my best. Oh, but the emails. All right. Where'd the emails go? Let's see. What have we got? Hunter's laptop. We've got, here. Nope. Oh, emails. The emails right here. We got the emails. They're coming back. Oh, you never miss. Well, I don't know about that. Oh, my goodness. Yes, Nixon v. Fitzgerald is not good law anymore. The case was in the 1930s, and it was brought up, or not the 1930s, but it's not a good case anymore. I'm already getting a little bit tired here, but what you need is Clinton v. Jones. That's the case that is the standard. If that's the case you're looking for, if you really want to know what the law is about presidents getting sued and being brought to court, you need to look up Clinton v. Jones.